Supreme Court First Department, he, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division. I'm about to call the calendar. When you hear your case called, please identify yourself and who you're representing and indicate to me the time that you need for argument today. I would ask that you please request only the time that you actually need, because based upon your pre-requests, we have over 6.5 hours of argument. So we would much appreciate it if you only asked for what you needed. The first case on the calendar, People versus Dennis Jennings. Oh. And how much? Say it again. 5 and 1. And you, sir? All right, 5, 1, and 5. Thank you both. Appleyard versus First Prestige.
What's up?
Time.
Good afternoon, Ernest Bonacore on behalf of Appellate respondent. 5 minutes, Your Honor.
Right, you'll get 5, 1. You'll get 1 for rebuttal, sir, and 5. All right. Debrook versus Rajiv D. Appellant.
5 minutes.
Respondent. 5, 2, and 5. Thank you. Pearlbinder Holdings versus Perlmutter.
Richard Leland for Appellant, 5 and 2, Your Honor, please.
Respondent, 5 minutes, Your Honor.
5, 2, and 5. Thank you. 15th and 5th versus LG Park Slope.
Good afternoon, Your Honor. They will stay the other.
5, 2, and 5. Thank you. RB and BB versus New York State Office of Children. How much time? Do we have a respondent?
No, I'm RICSD from the State Office of Children and Family Services.
6, 2, 5, and 5. Ortiz versus City of New York. Submitted. People versus Irizarry. Submitted. Strowther versus Thos Shore Parkway. Okay, and we had another appellant. Not here. Right. Canatal. Is there anybody? Well, we have multiple parties. For Thor. Right. How much do you request? 5 minutes. Okay. All right. So we have no appearance by Canatal, so that will be submitted. BJ Fries, you get 5 and 2, and Thor 5. Thank you. Diop versus Getty Square Realty. I didn't hear you. 3 minutes? Well, you're both here. I'll give you 5 and 3. All right, thank you.
Respondent too, Judy.
Are you both respondents here? And so nobody's here for Getty Square? Okay, so I'm going to change that actually then, sorry. Thank you to my colleague. I'll give you each 2 minutes. Baroque versus Columbia. 5, 1, and 5, thank you. People versus Rashawn G. is submitted. Corey versus Italy.
Respondent Clinton, request 5, Your Honor.
5, 2, and 5. Colfin SMP1 funding versus Security National.
Jeffrey Mitchell for the appellant, 8 and 2, please.
6, 2, and 6, thank you. People versus Ramos. 4, 1, and 3, thank you. Lopez versus Limpiex Cleaning. I'm sorry if I mispronounced that. All right, the 2 appellants will each get 3 and 2, and the respondent will get 4. Medina versus Millwood Market. 5, 1, and 5, thank you. Bacane versus City of New York. Do we have you're for the respondent? I don't have an appellant request for argument. Are you for the appellant or for the respondent? You're the appellant? Okay, and apparently the respondent who did pre-request argument time is not here. All right, sir, I'll give you 3 minutes for argument. Kim versus HFZ, that's submitted, and Dabrowski versus ABEX is submitted. First case on the calendar, People versus Dennis Jennings, please step up. You may proceed.
May it please the court, good afternoon, Your Honors. Jesse Weiss from Cravath, Swain & Moore, pro bono counsel for the defendant appellate, Mr. Dennis Jennings, along with the Office of the Appellate Defender. Your Honors, we argue for reversal of the conviction in our briefs and stand by those arguments for the reasons and with the support of the cases cited in our papers. But with my time here, I want to focus on the issue of the excessive nature of Mr. Jennings' sentence, which is one of 15 years incarceration, the statutory maximum. Mr. Jennings' co-defendant, Mr. McKinney, received a sentence of 9 years, and we submit there is no basis for such a large or any disparity between the 2 sentences. Maximum sentences should be reserved for the worst cases of the charged crime, and that's just not the case here. And there are 2 important points that underscore, we submit, the excessive nature of the sentence here, especially when compared to that of Mr. Jennings' co-defendant. One, this was not a planned robbery if there was a robbery. The video that captured the charged crime makes clear that Mr. Jennings was minding his own business that morning before the encounter with the complainant, focused on his friends. There were pedestrians that passed him by. They didn't bother him. He didn't bother them. He was focused on flirting with one of his female companions before his encounter with the complainant. If Mr. Jennings was out to rob someone, if this was a planned robbery, why would he let all those people pass him by and wait for the one person who was nearly a head taller than him, as can be seen in the video, that captured the incident and who happened to approach him from behind? And two, relatedly, it is clear that Mr. Jennings was reacting very wrongly and inappropriately, we concede, in the heat of the moment, in a very emotional and intoxicated state, after having been out all night drinking and commemorating the birthday of his deceased mother. Importantly, we and Mr. Jennings are not blaming the victim by highlighting the facts that are plain to see on the video with respect to how Mr. Jennings' encounter with Mr. Perez-Diaz was initiated and unfolded, and the uncontested facts in the record as to Mr. Jennings' intoxicated and emotional state.
Sir, did the
The facts-
defendant accept responsibility for his actions?
Your Honor, we submit he did accept responsibility for his actions. He maintained his innocence, and that was noted by the sentencing court, but he accepted responsibility for escalating the encounter. And when focusing on the disparity between the sentence of Mr. Jennings and his co-defendant, the fact that he continued to maintain his innocence doesn't distinguish the two cases. Mr. McKinney, his co-defendant, also pleaded not guilty, also appealed his decision, also challenged the weight of the evidence. And importantly, Your Honors, although, again, he's not blaming the victim, the facts and the context matter when assessing the reasonableness of imposing the maximum sentence here, 15 years. Now, just before the encounter, Mr. Jennings was flirting with his female companion. He was minding his business. The complainant came up behind him, touched him in what he felt was an oddly intimate way, and Mr. Jennings overreacted. Unquestionably, he overreacted to what he felt was an invasion of his private space, but the context makes clear he was reacting in the heat of the moment to that encounter while he was intoxicated, sleepless, and in an emotional state.
Counsel, I mean, you keep making reference to what the encounter escalated into, but it escalated more to just him overreacting. In fact, the video reflects that he flipped him over, took off his belt, took money from him. So it's just not that he overreacted. He overreacted that led him to this robbery charge, correct?
Well, Your Honor, he undoubtedly overreacted to what he felt was an invasion of his private space. He admittedly escalated the encounter. I think the video shows that the complainant leaned into the defendant, and that's when he hit the defendant. Mr. Jennings believed that the complainant had taken something from him, but he was, again, his actions should be assessed in the context of the emotional and intoxicated state in which he escalated those events. So he was absolutely wrong to do all the things that you see on the video, but a 15-year sentence we submit is not appropriate, and the disparity between his 15-year sentence and his co-defendant's 9-year sentence we submit is unwarranted given that context.
Was intoxication raised as a defense during the trial?
It was not, Your Honor, and we're not raising it as a defense here. Rather, it's just one of the contextual factors that should be looked at when assessing whether a 15-year maximum sentence is in the interest of justice in this case. Now, importantly also, Mr. Jennings was adjudicated a predicate nonviolent felon, whereas Mr. McKinney, his co-defendant, who again had a 9-year sentence, was adjudicated a second violent felony offender, and we submit that underscores the unjust nature of the disparity between the sentences. And we submit that, I see my time has expired, so we request that the sentence be reduced in the interest of justice to no more than 9 years. Thank you, Your Honors.
Thank you.
May it please the court, Michael Yetter for the people. Just briefly, defendant's legal sufficiency claim is unpreserved. As to the arguments against the weight of the evidence, we would also rely on the arguments we made in our brief and the conclusion that a panel of this court drew in co-defendant McKinney's appeal. The 15-year maximum sentence was warranted in this case. As Justice Klott found at the sentencing proceeding, we believe he made a fairly detailed record as to why that was. I'll just go through it briefly. The circumstances of the robbery, as Justice Klott said, were horrific and needlessly violent. Yes, Perez-Diaz touched the defendant on his back, and then the defendant pushed him. He could have stopped right there, but he didn't. He grabbed him by the neck, shoved him up against the door, reached into his pockets, punched him, knocked him unconscious, as both Perez-Diaz and the defendant testified, and then started searching through his pockets afterwards. Then the defendant testified at trial, and as Justice Klott pointed out, he lied. In particular, I think the starkest example of that has to do with the claim that he made that Perez-Diaz had a knife. The prosecutor asked him, "Where's the knife on the video?" Couldn't see it. "Did you find the knife?" when you search his pockets, didn't find an axe.
Well, counsel, can you just talk about the disparity between the sentences with the co-defendant receiving 9 years as a second violent felony offender and Mr. Jennings receiving 15? As a
Right, so
second
yeah,
felony
it's a
offender?
six-year difference here, and I think in part it reflects the level of culpability with respect to the incident itself. Of course, McKinney was prepared, willing, and able to use physical force. Defendant Jennings used the physical force here, caused a severe injury, and really escalated the incident. Then, as I was saying, he then lied about what he did at trial, and then, to my next point, he made a statement at sentencing that was bizarre and rambling, where he talked about the absence of physical injury and the display or use of a weapon. He asserted that Perez Diaz had attacked him when that was contradicted by the video. He claimed that he was defending himself, which was not true. He claimed that his attorney had buried his case and was seemingly acting as an agent for the district attorney's office. These are all things that the court, that Justice Klatt was entitled to consider and did consider in levying that sentence, and that explains why the sentence disparity is what it is. And I would also note that before trial, Jennings had 2 cases that were pending before the court. An offer was made by the people of 12 years to resolve both cases. So we think that, one, the maximum sentence is entirely appropriate, it should not be disturbed, but in the event the court sees some excessiveness, it should not in any way be below 12 years. Thank you.
Thank you. Rebuttal?
Thank you, Your Honor. I just want to briefly address a few points made by my adversary. One, my adversary pointed to the Mr. Jennings' conduct at trial, but there's no indication that Mr. Jennings displayed any violence, tendency for violence at trial. What did he do? He fundamentally maintained his innocence. You know, he's not a lawyer, but he cited what he believed was his interpretation of the statutory elements of the charged crime, and just like Mr. McKinney, he maintained his innocence. Mr. McKinney didn't testify, didn't purport to try and interpret the statute. Mr. Jennings did. That's not a basis for a 6-year disparity in a sentence. My adversary also pointed to the fact that there was a pending crime charged at the time of sentencing. Well, that led to a guilty plea to criminal possession of a weapon in the 3rd degree. Mr. Jennings was found with an imitation pistol or a starter pistol. It's a nonviolent offense, and he was given a 2 to 4 year concurrent sentence, which we submit indicates that the crime is not viewed as seriously as my adversary portrays it. Thank you, Your Honors. We request a reduction in the sentence.
Counselor, you're serving here pro bono, is that correct?
That's correct, Your Honor.
All right, we thank you for your service, and please thank your law firm as well for
Thank you, Your
allowing you
Honors.
to serve. I thank you both. Next case, Appleyard versus First Prestige Properties. You can proceed, sir. You can proceed.
Thank you, Your Honor. Frederick Gallen for the appellants, the defendants in this case. May it please the court. As I said in my reply brief, I think the real issue here, to me, is the complete absence of documentary evidence to establish the secondary residence. And I think this can be compared, when you compare the 2015 case from Justice Rosa in the medical malpractice case where the venue in the Bronx was appropriate, with the facts in 2019. With the earlier decision, the plaintiff had a Bronx driver's license. She had employment records, a pay stub which showed a Bronx address. When we come to 2019, none of that is present. She switched her driver's license from the Bronx to Ulster County. All of her employment is upstate. There's absolutely no documentary evidence other than the single People magazine cover tying her to the Bronx in 2019. It's our position that the fact that she may have had a valid basis for venue when she filed the malpractice case should not continue forever, that she has to show a continuous documentary presence. As I argued in my brief, by 2019, she's just, at best, she has a significant relationship with the Bronx residents, but there's no other evidence. Her driver's license, her insurance, her car registration, her license, her employment. Everything that shows where she's living is all upstate. And I think I made the point at the very end of my brief that by 2019, she has none of the obligations of a Bronx County or a New York City resident, but now she's trying to have the advantages of a Bronx venue based upon records that were stale at that point in time. So it's our position that in order to show that continuous relationship in the Bronx, she needed to have current contemporaneous records and should not be permitted to rely on records that were no longer valid, such as the prior driver's license. I know the trial judge, for example, also laid evidence of importance on the fact that the adult children spend time with their natural father in the Bronx. And I made the point in part of his decision, and part of my argument is, I don't see what the relevancy is of where the adult children choose to spend their time in establishing that this plaintiff lived in the Bronx. So I think this is a case where I have effectively an Ulster County resident who falls at an Orange County gas station, and this is a case that belongs where the people actually lived, and where the accident actually happened.
To what extent are we required to give deference to the the hearing court's findings as to the credibility of the plaintiff?
And at this point I made in my brief, Your Honor, in that I don't see this as a credibility issue. Even if you believe everything the plaintiff said, there's still an absence of objective evidence. And if this court's going to have venue decisions saying in order to establish venue, it has to be an objective evidence, and my position is it's not a credibility issue. Even if you believe everything that was presented by the plaintiff, as a matter of law, it's not sufficient to have established the Bronx venue. I think I'll defer the rest of my time if I might.
You might. Thank you.
Good afternoon, Your Honors. Ernest Bonacore for plaintiff respondent Audrey Appleyard.
Counsel, why don't you start by explaining what documentary evidence, besides the People magazine, showed that this plaintiff was a resident of Bronx County at the time she commenced the lawsuit?
Yes, Your Honor, thank you. In addition to the magazine cover, the magazine that she received at the Bronx address the month following the filing of the action, Your Honor, she did serve jury duty in the year before of this accident.
Wasn't that in 2016?
Yes, Your Honor. It was before this accident occurred. However,
and her jury notice was from 2016, not from 2019.
You are correct, Your Honor. But what better evidence of a commitment and a service to Bronx County than to be serving jury duty there? Judge, the test here is not contemporaneous documentary evidence. Respectfully, that is the test when a plaintiff has claiming one county of residence and moving, let's say, from Rockland County to the Bronx. There, this court requires documentary evidence that's contemporaneous with the move. In this particular case, she's been living in the Bronx and in First Dutchess and then Ulster County for 7 years. It is relevant to...
But what does she have to show that she lives in the Bronx? Her working license, her driver's license, everything is related to Ulster County.
Judge,
you have the People magazine. That's not even a utility bill.
She testified, according to Judge Johnson, in a credible fashion that there were reasons why it was easier for her to keep all of her mail going to one place, and that she would go back and forth on a approximately 3 to 4 day basis between where she was working up in Ulster County and to be with her fiance, Bill Vigor, in Bronx County, and to reside together first at the Randall Avenue address, and then when they moved together to the Hollywood Avenue address. So, Judge, the test here, respectfully, is what was her bona fide intent, and that was clear that it was retain that Bronx residence for some length of time with some degree of permanency. And that is the...
Let's get back to the documents, all right? Because this case seems to swirl around that. Was she required to show through documentary evidence that at the time the action was commenced, she resided in Bronx County?
She had documentary evidence.
I didn't ask you that yet. We're going to get there. Because then the question becomes, the nature of the documentation that she provided, was it sufficient to otherwise overcome what I think was the defendant's prima facie case, that she didn't live in the Bronx, at least not anymore. She changed her residence for employment purposes. She changed it for driving purposes. That's pretty strong evidence that she's no longer attached to the Bronx, even if she was at one time. So what documents address that prima facie case?
Judge, she does have the documents, as I mentioned, the magazine cover and the jury service.
But the jury service predated all of that,
Yes,
right?
that's true, Judge.
So,
But in this particular case, when a plaintiff has two residences, that's not the test. It's not contemporary documentary evidence.
well, you can have two residences, I'll give you that. But we're talking about the proof. People also move. They move. Their lives change over time. And just because you're a resident in 2015 doesn't mean that you're necessarily resident in 2019, true?
Of course, Judge, that can
Right.
be true. But in this particular case, her ties to the Bronx remain the same. Her children used the apartment. They went back and forth, excuse me, not the apartment, but the house upstate and the Bronx residence. Mr. Vigor and Ms. Appleyard, they are the biological mother and father of these two children.
These are adult
adults,
children, right? They're not even
Yes.
in school in the Bronx.
That's correct.
Okay.
One was going to college, the other was working in Manhattan, and they would both use both residences going
Well,
back
I'm
and
not
forth.
sure how much that means they're adults. I mean, you know. You know.
Of course, Judge. But I submit the test is the intent, the bona fide intent of Ms. Appleyard. Thank you, Your Honor.
Thank you. Rebuttal?
Just very briefly, Your Honor. The point about the jury service is the driver's license changed in 2017, so it makes sense she should get a 2016 jury service in the Bronx based upon a 2017 driver's license. By the time 2019, she's got an Ulster County license. She's not getting another.
Right, so she's presumably on the rolls to be called for jury service in Ulster because of
Correct.
the driver's license.
And I guess my fundamental disagreement with Mr. Bonacor is, you know, the fact that she had the valid evidence prior doesn't mean that she gets to keep it.
But isn't the ultimate inquiry whether she actually has she can have more than one residence? We accept that, right?
Correct, yes.
And isn't the ultimate inquiry really the truth of, does she reside in the Bronx?
To a certain,
Not necessarily the documents, but where does she actually physically reside?
I think based upon this court's prior precedents, for venue purposes, documentary evidence is something this court continually refers to. Otherwise, as I said in my brief, she's just a significant other of Mr. Viger, and I don't think that's enough to establish residence. Thank you, Your Honor, for your.
Thank you.
Thank you.
Okay, Brooke Arnow D versus Rajiv D. Step up, please. You may proceed.
Good afternoon, Your Honors. I'm here to appeal the excessive harshness of the sentence for order of protection that in the end led to sole custody. My opponent has already argued that there are hardly a few months left for the order of protection to expire. I've already done 24 courses of anger management and divorce and co-parenting, and almost a dozen of the domestic violence. So whatever the result of this is will be academic or inconsequential is wrong, because over here, the law system has been used to gain custody of the children and keep a father out that would take the children to school twice a week and put them to bed every night. So that's the argument I have. There was some text that were very old that were used, and there was a video which I feel was entrapment and trying to coax me into saying some things or bad words, which she equally used. In fact, during the case, we also argued that she had struck me. I had never struck her ever, but that was ignored. I thank the justices for this opportunity, and I hope. I also like to add that our relationship before the stay-away order, and even during the stay-away order, and even after now, at present, is very cordial. In fact, the court told her to use Family Wizard, which is used in cases where there is order of protection, but she continues to use email and phones to communicate about the children. We live 20 meters apart. We see each other every time we exchange children's. My relationship with my in-laws is excellent. I go to their house, I meet the children, I dine over there. So I just feel that this order of protection was used to gain advantage in divorce and custody. And I thank you, Your Honors, for your time, and I apologize for not wearing a tie. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Michael Todd Mueller for the respondent wife. Mr. Dixit just focused on custody issues. Custody was resolved by a settlement on August 5th of this year. The settlement of the custody issues had no relationship to the order of protection. The order of protection was granted because Mr. Dixit committed family offenses against his wife. Mr. Dixit mentions a video. In this video, during a short discussion about the fact that Mr. Dixit had moved across the street already, but was refusing to leave the marital home, Mr. Dixit said he didn't care. He called her a bitch. As the court described Judge Lupaloff, he turned on a dime and he lunged at her and he screamed. And any reasonable person would consider this to be a family offense and to be scared of that. Relying on that alone, a family offense is justified. Mr. Dixit believes the video was unclear. I hope the court has not had an opportunity to look at the video. I don't believe it was unclear. I believe it was clear, and I believe Judge Lupaloff found it was clear. Also included in our brief and at court are text messages. These text messages read that Mr. Dixit says, "Listen to my suggestions or die in misery and difficulty, I mean." That is a threat. That is also on its own enough for a family offense.
Sir, what is the temporal relationship between those texts and the family court proceeding?
They were relied on and specifically referenced by Judge Lupaloff in the family offense proceeding in Judge Lupaloff's order of fact-finding and disposition, to which he relied on the finding of a family offense. Mr. Dixit actually is only appealing the order of protection itself, not the actual order of disposition. With that being said, Judge Lupaloff also finds this behavior to be violent. And it's my belief that her reliance on these text messages and video, in addition to other evidence, was sufficient for her to find a 2-year order of protection. Mr. Dixit also mentioned this great relationship that he has with his wife. This is simply not true. Throughout his papers, he relies on this fact that he had a great relationship, that the evidence submitted at trial does not show a family offense. It was not shown at trial, and it's simply not true. Mr. Dixit lives across the street. Miss Dixit, my client, needs this order of protection. But for the order of protection, her life is certainly in danger. The parties do not get along. I know that's outside of the evidence, but this order of protection is needed. But I do think it speaks to Mr. Dixit's misunderstanding of both the law and proper behavior. He defends the video as being no big deal. He says that her behavior was worse. The behavior in the video is unexcusable. Nothing my client could have or should have done before or after the video excuses his behavior in the video. Likewise, the text messages are unexcusable. Mr. Dixit characterizes it as normal. That's how men and women talk to each other. This is simply not true, and there's no evidence in fact or law to support it. Finally, there's a picture of a trash can that Mr. Dixit crushed during an argument. It's in the papers. There's no excuse for this type of behavior. I have nothing further, and I thank the court for its time, unless the court has any questions.
Thank you.
Thank you.
All right, sir, you have 2 more minutes for final thoughts and argument.
At no point, I'd just like to say that I condone my behavior. I apologize for bad language and kicking the trash can. But I bear no hate or bitterness towards the opponent. That's all. Thank you.
Thank you. Thank you both. The next case is Pearl Binder Holdings against Perlmutter. Step up, please.
Good afternoon, Your Honors. I'm Richard Leland of Ackerman for the appellant, Pearl Binder Holdings. This is a case involving what we believe is an arbitrary and capricious and denial of a variance based upon justifiable reliance on a permit issued by the Department of Buildings. And it wasn't just a typical permit issued by the Department of Buildings through the normal process of a plan examiner looking at an application, or the normal process of a self-certification of an application by an engineer. But this is a case in which specific objections were raised by the plan examiner, and the appellant went through the recon process and met with and provided evidence to the Borough Commissioner of the Borough of Manhattan, and the objections were cleared, and the permit was issued. And then 26 months later, the permit was revoked, and the BSA wrongfully made a determination based upon nothing but speculation that my client had no basis to rely upon the permit or the clearing of the objections that was made by the Borough Commissioner. Now, the Borough Commissioner is the highest authority in the Department of Buildings in the borough.
Well, isn't the issue really whether the application for the variance presented a sign that was substantially similar to the sign which was built in reliance on the wrongly approved permission from the Borough Commissioner? I mean, isn't that really what we're talking about here?
No,
What means good faith?
No, I don't think so. I think the question is, can the BSA make a determination based upon no evidence that, and change and reverse the roles and say that an individual applicant should know more than the Borough Commissioner about the validity of a permit?
Well, I don't think that's really the issue, honestly, because that issue about whether the permit was rightly or wrongly issued went up and litigated and went to the Court of Appeals, and they said you have to bring a variance. So we're just looking at the variance application now, and you're trying to come under the provision that talks about good. I think the standard is good faith reliance, not necessarily justifiable. Good faith reliance. So as I understood the case, the question is, what means good faith? Are they entitled to deference on their determination that this wasn't a good faith reliance?
Now, I agree that that's the legal issue here. But this
what
is,
else?
I'm not bringing up what happened in the earlier case, which was an appeal, in which the Court of Appeals said you can't raise good faith reliance on appeal.
Procedurally, right.
But the issue here is that there is no real basis for the BSA having determined that there was no good faith in the reliance.
Even with giving them the deference that should be accorded to an agency.
That's correct, because their determination that there was no good faith reliance or no right to rely is not based on anything other than supposition. The objections to the sign that were raised by the plan examiner were all presented to the Borough Commissioner, and the Borough Commissioner ruled on them.
But
What
sir,
was the appellant to do?
as I read the BSA's March 19th, 2019 resolution that led to your current Article 78, it seemed to me the central thrust of the BSA's finding was that there were material inconsistencies in the submissions made to the Borough Commissioner.
That's correct, but those were before the Borough Commissioner. And so, and despite the fact that there were inconsistency, the Borough Commissioner cleared the objections. That's the process. What was the appellant to do once the Borough Commissioner cleared the objections? Was he to take an appeal from a favorable decision to the BSA or to the overall commission?
Well, part of I guess the good faith requirement is Justice Gish was talking about the elemental test. One of those elements, as I recall, is there some suggestion or some indication that would put the developer on notice that the permits may be on shaky ground? And here, if there are these material inconsistencies in the paperwork underlying the application to the Borough Commissioner,
if I may,
could that provide some, because we're talking about rational basis, right? Could that provide some support for the BSA's present determination?
No, I don't think so. And if I may, even though my
You may answer that question.
First of all, the inconsistencies had to do with a lot number on a particular block. Those were the only inconsistencies. But those inconsistencies were there. To jump from those inconsistencies to, well, you should have known that the Borough Commissioner was wrong, is to me a very substantial and substantive jump, particularly for an agency that's charged under the charter to do substantial justice.
Okay, thank you.
Thank you.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of the BSA. There was a more than rational basis for the BSA to have concluded as it did that Pearlbinder, a seasoned developer, could not have reasonably relied on the Santulli authorization. Their own submissions, rather than clearly, comprehensively, and transparently addressing the key issues of which it had actual notice, instead provided confusing and inconsistent information, and Pearlbinder could not even say for sure what Santulli had in fact signed off on. On page 51 of the record, Pearlbinder calls the new sign a direct replacement of the old sign, but its submissions tell a different story.
Can I ask you a question, though?
Yes, Your Honor.
This was troubling me in the record. In the prior appeal, right, we, the appellate division, looked at the record, and at what we believe that the issue of the good faith variance could be addressed in that earlier proceeding, and the Court of Appeals said, no, that's not the case. But we did make a finding as a matter of law that the applicant, the petitioner here, had acted in good faith as a matter of law. Did anything in the record change when it came before the BSA on the new variance application that was really based on the same set of facts?
No, Your Honor, and we are looking at the point in time in which Santulli gave authorization for the sign here, but walking through the record, Pearlbinder's submission...
So why were we wrong in that?
Well,
I mean, that technically, that wasn't reversed. It wasn't addressed by the Court of Appeals. It kind of went out baby with the bathwater. But why was the reasoning that led to that conclusion wrong?
So I disagree with you, Your Honor, that that wasn't reversed by the Court of Appeals in its decision. But in any event, looking at the...
Not expressly. They didn't express findings. They said it was the wrong... You couldn't address the issue of good faith because you needed a variance application.
And they have now applied for a variance application.
Right.
Looking
So
at the
what
facts,
factually changed?
So nothing changed. It's that from that point in time, they could not reasonably rely on the Santulli authorization, given that their own submissions referred to 5 separate tax lots. They had actual notice that the sign needed to be in the same location, have the same height, and not increase the degree of illumination, which it would since it was a double-sided nature. The engineer who testified before the BSA, he included at pages 647 to 653 of the record all of the information that he says he provided to Santulli. It did not, in fact, include the Department of Buildings objections. And moreover, he admitted at page 727 of the record that he wasn't even sure if Santulli knew that the sign was double-sided. Here, these inconsistencies, they were red flags because a reasonable applicant uses professional care to put together consistent materials addressing key questions. There should never be an issue about whether what the commissioner signed off on, whether he was confused. This distinguishes Pearlbinder's situation from the situations of the developers in cases like Woods or Rayner Estates, because this is really a self-inflicted injury here. And the BSA knows what an application of this kind should look like. It used its technical expertise to apply a multi-factor good faith reliance test to the record evidence that Pearlbinder had adduced here. Pearlbinder doesn't squarely dispute that, it just wants a different result. But under well-established Article 78 principles, this court should reject that invitation to substitute its judgment for that of the BSA when there was a more than rational basis based on Pearlbinder's own submissions that they could not have relied in good faith on the Santulli authorization here. Indeed, in the reconsideration application, they admit as much when they say that the sign was not in the same location, but only substantially so, and even conceded that it was much lower in height. This court should affirm.
Well, the original sign was on a building, right? Wasn't it painted on
The
the side of the
original sign
building?
was on a building that is no longer in existence.
And the buildings are gone from that lot.
That's correct. And I'm happy to walk your honors through the different inconsistencies in the record, since I heard my adversary not refer to the record at any point in time, but they're also referred to in our brief.
I think we're familiar with the record and your brief.
Okay,
So
unless
my colleagues have a question. Okay,
thank you, Your Honor.
thank you. All right, rebuttal?
Yes, Your Honor. I think when the court, this court first had this case, there was a finding of justifiable reliance. And as my adversary just conceded, there's no change in the facts. And the original application that was put in 2008 was part of the record before the BSA, the same record. The only differential is that in 13 years later or 11 years later, an engineer said, well, I don't remember what was given and what wasn't. But what was given to Commissioner Santulli was before the board, and was before the board in the record on this particular variance application. And so this concept that they were inconsistent, and somehow Commissioner Santulli couldn't wade through these inconsistencies and therefore was, quote, confused, and therefore, because he was, quote, confused, that Mr. Pearlbinder and his people had no right to rely is supposition upon supposition upon supposition.
Well, is it curious that the borough commissioner would address in I think it was a handwritten notation, specifically one of the three objections, but not mention the other two?
But he cleared them. He had to have cleared the objections just because he made the specific finding with respect to the degree of noncompliance, but he cleared the other objections. Because, this argument about the two-sided sign, that was always before them. And if you look at the provisions in the zoning resolution about how you measure the size of a sign, a two-sided sign is one side for the purpose of measurement. So again, there's no rational basis for the big jump to say, well, the applicant who, according to my adversary, is a, quote, seasoned real estate person, can't rely on what the high authority says. When the law, even cited by the BSA in its resolution, was that the test is, did someone get this determination and get assurances from a high authority in the Department of Buildings? That's what the BSA said the law was, and they never followed it. Thank you.
Thank you. Thank you both. Right, the next case is 15th and 5th versus LG Park Slope. You can proceed.
Good afternoon, Your Honors, and may it please the Court. Kayvon Sadeghi on behalf of the appellant. Your Honors, we ask that the Court reverse the trial court's order and grant summary judgment in favor of appellant. This case is about the breach of a commercial real estate purchase agreement at the outset of the COVID pandemic. Appellee, the purchaser, backed out of the deal on the eve of closing, but did not want to give up its security deposit as the
Right,
contract
we're
requires.
aware. Under your understanding of the contract, what were the purposes of the tenant estoppel certificates? What function did they serve?
Sure, there are a couple functions, Your Honor, and some functions of the estoppel certificates are set out by this court in Orchard Hotel, a case cited
No,
in
no,
our
I'm
brief.
talking about in this particular contract.
Sure, they verify the
What were they
representations.
for?
They verify the representations made in the purchase agreement that there is a valid and binding lease, which is true, that there aren't defenses being asserted to it, which is true, and there is a commercially reasonable effort prong to obtain this certificate. But I think the key thing here, Your
So
Honor,
what would be the remedy if that provision wasn't complied with? What remedy would the purchaser have?
what remedy did purchaser have?
Well, say for instance, in this case, that the tenant estoppel certificate requirement was not complied with. What would be the remedy for the purchaser under the contract?
Well, Your Honor, the issue here, and I think you have to look at section 6.03 of the purchase agreement for this. Section 6.03 of the purchase agreement, which is in the record at A42, makes clear that if any space is vacant on the closing date, purchaser shall accept the premises subject to
No,
such
I
vacancy.
understand that. I'm asking you, under this there is a requirement for a tenant estoppel certificate, is there not?
There is commercially reasonable effort to obtain one.
I understand that. I read your brief, okay? All right, so if there's non-compliance with that, what's the remedy under this contract? Any? Is there a remedy?
Under this contract, it is not a material breach if there is not a tenant estoppel
So there's
certificate.
no remedy?
It
I
is-
mean, I understand. We have to figure out, is it a material breach? Is it not? What was it for? What were the tenant estoppel certificates doing in this case? And I'm asking you, it was a provision. So if they didn't have the right to otherwise say, we're not going forward with the contract because you didn't comply, what were the rights under the contract if you didn't fulfill that obligation? Or are there no remedies?
It is not a material breach, Your Honor. I think there are other provisions.
Again, I don't think I'm getting an answer.
There's no particular remedy. If there's a particular,
remedy.
If there's a particular issue that goes to the representations in the contract, if, for example, the representation that there was a valid and binding lease was not true, that would provide a remedy. There are other provisions of Section 10 saying all the keys have to be delivered at closing. A
So in
breach
other
of that
words,
is
if
not.
in this case, let's just say in this case, the tenant estoppel certificate for Crunch said through April of, I think it's 2020, the rent is paid through March, but they're in default through in April, and that were accurate, that would be end of story, you complied, done.
Correct, because that is consistent with the deal that was struck in the contract as to whether that is a condition for closing. The deal makes clear, Section 6.03 makes clear, that they have to close, the purchaser has to close, even if there's a default or a vacancy or anything else.
Right,
a
so under the
certificate that says that
contract,
is
the
consistent with the
risk
representation.
of a tenant being in default during the period between the contract and closing fell to the purchaser. Didn't matter what that tenant estoppel certificate said.
Correct, on that point. That's exactly right.
All right.
That's exactly right, Your Honor.
Counsel, I have two questions. Just in terms of the commercially reasonable efforts that were taken to secure a estoppel certificate, and then I'm wondering, the timing of this is right in the beginning of the pandemic. Should we use that as in our consideration at all?
Yes, so there were commercially reasonable efforts taken, and the two questions relate to each other. I think the timeline is important here. So the deal closes on March 16th, which was the same day that this court shut down and many things had already been shutting down. After that, the Crunch tenant alerted our client to the fact that it was going to request a deferral of its April rent at the end of March, and my client alerted the purchaser to that on March 31st. It was at that time that the purchaser suggested and requested a revision of the estoppel certificate to include April rent. That was the first time that had been requested. And the signed certificate that made clear that rent had in fact been paid through March was provided on April 7th. That is the commercially reasonable effort. We could not obtain a certificate that said rent had been paid through April. That was not true. We could obtain a certificate that testified as to the accurate facts as of that date. That is what we provided. Those facts are consistent with the conditions under which purchaser was responsible to close, and as a result, it was materially complied with.
Okay, thank you. Let's hear from your adversary.
May it please the court, Henry Masho, Rivkin Radler, attorney for the defendant, Park Slope. Tenant
All right, under
estoppels,
this contract, what were the purposes of the tenant estoppel certificates? What purpose did they serve?
they were a key part of this bargain, and they
Why?
served two purposes. First, they provided LG Park Slope with certainty about the status of the rent payments,
But
which was
even
necessary.
even if you got certainty, it wouldn't change the risk.
Yes, that's true, but they still
So in
needed
other
that
words,
certainty.
right, all right, let me just follow that up a little bit.
Sure.
Because this is the main thrust of their argument. Had that tenant estoppel certificate said that Crunch was in default for April, you would have had to close anyway.
That's right.
Right.
But we still needed that certainty. We bargained for a definitive statement
Well, wasn't
from
it,
the
let
tenant.
me ask you a question. Was the tenant estoppel certificate, the purpose, one of the requirements was that it be in satisfactory form for a bank, right?
That was one of the potential
And
forms that
isn't
you
it
could use.
because, at least in this case, while you were assuming the risk of a tenant that may not be in default, that the bank that you may have been seeking financing from
Mm-hmm.
didn't necessarily have to do the same, that they wanted
Correct.
to see a rent roll.
Yep.
All right? But you didn't have a mortgage contingency in this
That's
contract,
correct.
did you?
But
So again-
those aren't the
so
only
again,
purposes.
What was the tenant's estoppel certificate for?
Well, there are other.
From and I want you, I don't want you to say, oh, it was part of our bargain. I don't want that general stuff. I want to know from the structure of your business deal, what was this supposed to do for you?
Well, it also had a prospective benefit because a tenant estoppel binds the tenant. That's a legally binding document on the tenant, and that has value to the buyer.
So the tenant would have been buying that they didn't pay April rent.
Then we would have had to close. But we didn't get that. We didn't get a definitive affirmative statement from the tenant, and that's what we bargained for. And that has prospective value because it binds the tenant. It's not just about certainty and about knowledge. That's important too, and it is important for the lender, but it's also important because it binds the tenant going forward. And that was one of the things that we bargained for, and that's what they deprived us of.
Counsel, I mean, I have the same question in terms of the COVID-19 pandemic. When everything shut down, everyone was asking for a deferral in rent. How should we look at that, what you're saying is a material breach in light of what was going on in the world?
What was going on at the time explains exactly why we needed a tenant estoppel certificates. Everybody knew that there was a risk going forward that some of the tenants might not pay, and that's why we wanted a definitive statement from those tenants about what the status of their rent payment was. We assumed all that risk, and as a result, in exchange, we wanted a statement from the tenants that would be binding going forward. That's what we bargained for, and that's what we were deprived of. And I'd just like to close with one final thought. The commercial real estate market needs certainty in order to function. The Court of Appeals has recognized that many times. And in this case, LG Park Slope bargained for the certainty that comes with tenant estoppels. The plaintiff deprived Park Slope of that certainty by providing tenant estoppels that omitted an affirmative statement about the April rent. And as a result, they failed to meet an obligation of closing. And as a result, they should do the right thing and return our deposit to us. And because I think this will come up on reply, I'd just like to note that the seller's estoppel was completely insufficient for two reasons. First, that was only permitted if the tenant provided a blank estoppel or didn't respond at all. And the reason for that is obvious. There are sometimes maybe the tenant wouldn't be responsive or difficult to find, or maybe they weren't obligated to provide one. But in this case, we know the seller was able to contact the tenant, and we know that the tenant was obligated by the lease to provide one. Second of all, the seller did not use commercially reasonable efforts here. On page 252 of the record, the seller admits that he just gave the estoppel certificate to the tenant and said, the tenant gets to make whatever changes they want because there's no form that's required. That's not commercially reasonable. That's an abdication of their responsibility because they had every right under their lease with the tenant to require that tenant to provide an estoppel certificate. They didn't do it. They completely abdicated their duties, and as a result, we lost a benefit of our bargain.
Okay, thank you. Rebuttal?
Thank you, Your Honors. Just a couple points. One, we did provide a signed estoppel certificate. That's at A257 in the record. It was emailed to them. That's the email is at A256. It clarifies that rent was paid through March 31. They did get the certainty of an actual tenant estoppel certificate from Crunch, signed by the CFO of Crunch.
Sir, which of the three forms of estoppel letters did that satisfy?
It is not specifically any of them because, for an important reason, they are trying to rely on the fact that the form was supposedly reasonably requested by their lender, the original form that was sent. The problem is they alerted us that the bank that sent that was no longer their lender. So their actual lender, they didn't have a lender after that. So there is no reasonably requested by their lender form because they have no lender. And their lender is not the person who is requesting April rent be put into this certificate. It is only the purchaser who's making that request. The other provisions don't apply. They are trying to insist on a form from their prior lender that they weren't going to go forward with. And the entire dispute comes down to whether the modification of that to be accurate to the facts, which is that rent was paid through March, is somehow a material breach of this contract, even though under those facts they are required to close.
So I'm sorry, sir, are you saying that under the circumstances, the way they unfolded and the fact that they decided to simply go with cash and not finance the purchase, that none of the three specified forms would have been applicable?
Correct.
Okay.
Correct, because they can't have a form reasonably requested by their lender if they have no lender.
But there were two other types of forms that would have been satisfactory, right?
One was if there's something attached to the lease, that didn't apply here either, and I can pull
The other one was a letter that was previously, I think, used by a tenant.
Yeah, again, none of these would have addressed the issue that is at issue here, which is it going to require that it's current as of closing, which simply doesn't apply here because this contract does not require that.
Okay, thank you. Thank you both. Okay, the next case is RB and BB against the New York State Office of Children. Are you ready, Counselor?
Yes, good afternoon. My name's Andrew Citron. I'm here to argue the case on behalf of the appellants. I'd like to first address, this is an expungement case, an Article 78 proceeding. I'd like to first address the father, and hopefully I'll have time to get to address the case against the mother. Regarding the father, I just briefly summarize the legal standard, which is that there has to be a fair preponderance of the evidence, there has to be substantial evidence, which a reasonable mind might accept. Hearsay can be used in these proceedings as long as it's sufficiently relevant and probative to consider constitute substantial evidence. And we are relying on cases, including from this court, indicating that hearsay cannot be used if it's seriously controverted. And in this case, we submit we meet the standard for that. The reason being that everyone involved in this incident denied it, or would have denied it if they were permitted to testify, and that's one of our other issues, is regarding the daughter being excluded as a witness. But they all denied it, the father, the mother, the daughter denied it 2 days after all this hearsay was generated. And in addition, there's no physical corroboration or any objective evidence of any kind telling you what happened here at all. So we submit that, I cite a case, happens to be a third department case, Gerald H.H., which I suggest is very similar. Also, I used a case in reply that the respondents cited, which I'm probably mispronouncing, but it's Bayoji, perhaps, 251-82nd 133, where this court again went through the issues. Is there objective evidence? Is there sworn testimony on the other side? Is this the type of hearsay that should be relied on? One final thing I would say regarding this is that you can't just keep on adding on more hearsay, particularly when it's all coming from the same source, and try and argue that that makes it substantial. Hearsay could have a lot of details to it, but when you're trying to corroborate hearsay or provide some kind of support for it, you need something a little bit more objective than just that the person who wrote this has a very active imagination and wrote down a lot of details. So a related point, a related point is the exclusion of the daughter as a witness, which the daughter at the time of the hearing was 17 years old, and she'd hired her own attorney to represent her, who was an experienced attorney in these types of matters, who represents children in family court. What happened as a result here of her being excluded is essentially her testimony was discredited without even hearing her. This issue of what they refer to as her recantation, or whatever her present story would have been at the time of the hearing, and was starting from 2 days after she made the statements to the pediatric office, was the central issue in the case. And if you read the administrative law judge's decision, that's what it all, I'm not sure what that light means, but does it mean I'm running out of time?
It means you have 2 more minutes.
Okay. So briefly, even if the respondents argue there's a New York State policy about traumatizing witnesses, but that policy clearly does not apply here. I don't think even under New York State law, this court is required to give that amount of deference to a policy that makes no sense in the facts of this case, but even more so, we argue that it's a violation of due process, the essence of which is to be able to confront the case against you and present evidence. And of course, I point out regarding trauma that the respondents interview these child witnesses all the time and use them to their own advantage. So I submit that that violated due process, as well as New York State law. I cite the regulations that these respondents have permit child witnesses to testify. Briefly on the case of the mother, I'd just like to say that if normally in these kind of cases, when you're dealing with someone who's not alleged to have done any misconduct, you very carefully go through the building blocks of all the evidence. You know, if this was a standalone case about a parent who was supposed to have neglected their child, every element of this would be gone through very carefully. So here we have the caseworker and the administrative law judge both saying, acknowledging, the mother did everything she was supposed to do, with some arguable exceptions, which I'd like to discuss. But meaning the main components of this, which is the father was excluded from the house, and there were orders of protection, and the orders of protection were not violated, and okay, so what are the things that she supposedly did not do, and...
Counsel, she was told within 24 to 48 hours to have her daughter seen by specific psychologists that are trained to deal with the community and with these kinds of issues. She waited a whole month before doing that, correct?
If I may, that's very, it depends very carefully on what the exact terms of the safety plan were, but she did take her daughter to a psychiatrist immediately. I could, we have the case citation, we have the record citations for that, and she took him within 2 days. She took her daughter within 2 days. That therapist recommended that she see a female therapist, which she saw a month later. Took some time to find a female therapist, but that depends very heavily on what the terms and conditions, so to speak, of the safety plan were. The safety plan is not a written document. There are different versions of it, and many of them don't even mention that condition. And some that do, when I say many of them, I'm sorry, when the caseworker testified to what the safety plan is, she did not mention that condition. Okay, many of them do, but they don't use the word immediate. And I submit, if you go through the language, the one citation says, it says that she has to take her and have an appointment. I don't believe it says that, I don't believe it says that it has to be with, no one made an issue below of whether this therapist was sufficiently experienced or understands this community well enough. She took her, and again, the other thing I'd like to emphasize is there was no evidence that a 1-month delay impaired the daughter in any fashion. If this were a standalone case, that would be a very important issue regarding a parent. Is this just bad parenting, or is it something which they should lose their job over, their career over? There would have to be specific proof of impairment. That was completely lacking here. So, okay, the other things that the mother is claimed that she didn't do. It's claimed that, well.
I'm going to ask you, because you're beyond your argument time, which I've allowed you to go forward, but I'm going to ask that you wrap it up and you'll have time on rebuttal.
Yes, I appreciate that. Thank you very much. I'll just briefly touch on the other two issues. This community pressure.
That's not really wrapping it up, two issues.
Okay,
honestly, I understand the importance of this case, so I'll let you say it briefly, sir. Briefly.
Okay. I don't want to. I don't only if I'm permitted. I don't want to.
I'm permitting you.
Okay, thank you. On the community issue, the glaringly obvious part about this, whether if you went through this hearsay and you didn't have problems with being single, double, triple, quadruple hearsay, if you didn't have problems with that, there's a lot of hearsay about other people. But when it comes to the mother, all it says is the daughter asked her, should she talk to these people that were in the house? And the mother said eventually that she should. There's no proof that the mother was part of any conspiracy plan. And again, I emphasize that if the mother were the only respondent here and she was a parent who's being given the same presumptions as any other parent, no one would try and construct a case against her based on that. And similarly, regarding this allegation that the mother saw the father in bed with the daughter, which even one of the two respondents refers to as rather attenuated hearsay. There are different conflicting versions of this, and one of them is quadruple hearsay, but most importantly, it contradicts the ACS's own records, the first page of which practically says that the mother first learned of this on May 1st. So again, and further, of course, there's no proof of impairment. To the contrary, if you read the records, you'll see that according to this hearsay, the mother stopped the father from doing that. There's no attempt to build a normal case here.
Thank you. All right. Counselor?
May it please the court, Ari Savitsky for the State Office of Children and Family Services. The ALJ's decision to maintain BB and RB on the state central register was supported by hearing testimony based on numerous interviews with one of the pediatricians and with the nurse practitioner and with the mother. Not one source, 3 sources. Independently supported by contemporaneous medical records, again, from multiple sources, a pediatrician and the nurse practitioner, both of whom described the victim's outcry about the sexual abuse she was experiencing. And the decision was supported by the credibility determinations made by the ALJ that are best left to the fact finder. So we think this court should affirm, because the evidence in this record easily satisfies the substantial evidence standard.
Yeah, by the time the hearing took place, the child was 17, is that correct?
That's correct.
All right, so why, and the child had recanted the story shortly after she reported it, within a matter of days, correct?
That's correct.
Right, and the ALJ accepted that she had recanted, and in fact, you know, the case law is filled with the concept that it's not uncommon for a child who's a victim of abuse to recant, correct?
That's correct.
But this case did turn on the credibility of the recantation versus her initial statements, which there isn't that much dispute that she made them to the people who otherwise were professionals and they mandated to report and did in fact do so, correct?
So I would take...
What I'm getting to, I know I'm going long-winded, but I really, you know, I just have a question about the rationale for not letting the child in this particular case come and testify at this hearing, and what impact, if any, does it have on the outcome?
Right. So I don't think that it has an impact on the outcome here because for several reasons. First of all, I mean, the evidence of the outcry, the evidence that this complaint was made in vivid detail was massive, both to a pediatrician, separately to and to a nurse practitioner, both of whom heard it. The mother heard it. All of them relayed this to the ACS caseworker, and then you also have these contemporaneous medical records. So the evidence supporting this outcry and showing that it's quite credible is significant. There's also a huge amount of evidence in this record about the retraction, the nature of the retraction. I mean, you have, again, contemporaneously documented that the victim repeatedly said she would lie if pressed, she would lie to protect her father and her family. There's the 1 a.m. phone call that she makes when she says, people are being sent to my house and telling me to lie. There's the evidence that she says she's worried about the consequences if she tells the truth and comes out. And of course, there's the ACS caseworker's testimony from the forensic interview saying this looked like they were coached. She and her sister, who supposedly haven't seen each other, are using down to the same verbatim stock phrases to give their story. So the evidence that the ALJ relied on to come to this conclusion was huge. And the ALJ didn't. This isn't a case where the ALJ said, I'm not going to hear any evidence of the retraction. What the ALJ said, and this is completely discretionary to decide which live testimony you hear, what the ALJ said is, and she took proffers, she had the papers, she considered whether it was necessary to also bring in a girl who's a minor victim of sexual abuse and to put her on the stand when it was acknowledged that if you put her on the stand, she will be grilled over this retraction and potentially re-traumatized. And the court said it's not necessary to do that in this case because the retraction itself is already in the record. And given the massive amount of evidence, clearly way beyond substantial evidence supporting the ALJ's determination, I think it was no abuse of discretion for the court to say we don't need that in. And I would just point the court to the Charlotte MM decision we cite because the third department looked at a very similar set of facts where you had an ALJ who sort of had a general policy not to have child sexual abuse victims testify in these types of proceedings unless it was really necessary. And the third department said that that's appropriate. It's appropriate exercise of discretion.
Sir, didn't the ALJ allow the parents to fully testify, countering all the so-called claims of abuse, and offer their own narratives, correct?
That's absolutely correct. And not only did the ALJ allow both parents to testify, the ALJ also allowed Dr. Barrell, who is a psychologist who was hired by the parents to examine Elle to testify as well. So the ALJ allowed plenty of evidence about this retraction as much as they desired into the record. What the ALJ didn't do is potentially subject the victim of a minor victim of sexual abuse to re-traumatization when there was no need for that.
Okay, thank you.
Thank you.
We'll hear from the attorney from ACS. Yeah, pull it down.
Good afternoon, Your Honor. May it please the court, Rebecca Viscatus representing ACS. There is no basis to disturb the OCFS determination, which is supported by substantial evidence. Without repeating too much what my colleague representing OCFS just covered, I do want to focus on a few things that appellant brought up. First of all, regarding the child's proposed testimony, as my colleague just explained, the ALJ reasonably concluded that there was enough information in the record already that it was abundantly clear that the child, if she did testify, she would repeat the same recantation that she had repeated multiple times at that point to multiple people that was in the record in all of those forms. In addition, the ALJ, weighing the value of hearing that recantation again with the possible trauma to the child and the risk of undue influence, especially in light of the fact that there was already evidence that she had been subjected to undue influence, the ALJ was in a position to conclude that there would not be much to gain from having her testify. At that point, the child had already had 2 years to practice that recantation and, in fact, had done so, giving it to multiple people, sometimes in interviews with Dr. Barrow with her parents present. And the ALJ was able to reasonably determine that in light of that, there would not be much value to gain from hearing that recantation in person, that it would not enable the ALJ to, it would not give the ALJ much more to base her credibility determinations on in light of the information that was already in the record. I would also like to address a few of appellant's arguments about the evidence against the mother establishing her maltreatment of the child. The question is not whether the mother complied with the safety plan that was developed. The question in examining whether there was an indicated report of maltreatment was whether she failed to exercise a minimum degree of care and whether that put her daughter at risk. So regardless of the exact timing of when she should have obtained therapy under an agreed upon safety plan, I would say that it is fair to say that a reasonable parent exercising a minimum degree of care for their child would not take over a month to find a therapist for their child who had just made serious allegations of sexual abuse by her father. So I think that the issue of what was in the safety plan is really a bit of a red herring. I would also note that the issue of the mother previously having seen the child and her father in bed together, that fact alone was not coming from an outside source. That was something that, based on the medical records, the mother had told the nurse practitioner directly. The additional detail that they had been unclothed when she saw them in bed together was the detail that the medical records are very clear that was the part that was coming from the outside community organization representative. But to dismiss all of this as hearsay that was not coming from the mother directly to the medical practitioners is a misstatement of the record. I would also just note that in general, appellants are really asking this court to reweigh the evidence and make its own credibility determinations, but that is not this court's task in performing the substantial evidence review here. That the facts and reasonable inferences that can be drawn from the record clearly provide a rational basis for the agency's determination that the state central register report was properly indicated based on the child's detailed allegations describing in detail the sexual abuse that her father had subjected her to over a period of years, and her reports that almost immediately members of her family and others in her community were encouraging her to recant. Based on that evidence, which was objectively established in the medical records, there was clearly a rational basis for OCFS to determine that the abuse and maltreatment at issue here were properly indicated.
Thank you. Okay, rebuttal?
Just briefly, on a couple of issues. One is on this idea that this hearsay is coming through multiple different sources, and that for that reason is actually, one of the attorneys referred to it as a massive amount of evidence. I'm quoting here to the record at page AR 53, where one of these three sources, Dr. Kaplowitz, that page discloses that the daughter was reluctant to talk to him, and he suggested, in fact, that at that point she should talk to the nurse practitioner. And the same is with the mother. It's the nurse practitioner who's hearsay from her that's indicating, what occurred here. So the daughter had like a brief encounter with the mother and with this other doctor that we say was orchestrated by this nurse. So I don't believe that's a massive amount of evidence. We also have a point regarding these medical records. I objected as they were not contemporaneously kept. I happen to be the same attorney who handled the case in family court, and they were subpoenaed and they were produced at different times, these supposedly contemporaneous records. I objected. Normally, a record certification has a notarization, so you know who's certifying it. This, although it contains the name of the doctor, just has an illegible signature, and there was no witness for us to voir dire, so I would not view those medical records as even medical records. They consist, again, of the same nurse practitioner writing something up out of court, and they don't meet the standard for evidence. The only other note I'll make here is this third department case about this policy. Charlotte, I think, supports our position, and the reason is that the testimony to be offered by the children was radically different in that case. The proponents were offering unsworn statements of the children, and there were already other unsworn statements in the record. We were offering sworn testimony under oath at which the key issue in the case would be presented in front of the hearing officer with a chance to actually see the witness to make what could amount to a real credibility determination.
Thank you. Thank you all. Strother versus Thos Shore Parkway.
Good afternoon, Your Honor. My name is Andrew Showers for BJ's Wholesale Club and BR Fries and Associates, the appellants. May it please the court. The court below erroneously granted that part of Thor Shore Parkway developer's motion that sought contractual indemnification against BR Freeze. In addition, the court should have granted contractual indemnity in favor of BJ's against Canatel, and also we oppose Canatel's cross-appellant's brief, which seeks to reverse the lower court's order insofar as it correctly granted BR Fry's motion for summary judgment on contractual indemnification against Canatel. Thor Shore failed to carry its summary judgment burden, and the contractual indemnification provision herein was never triggered. Thor Shore also failed to proffer any evidence of any negligence on the part of BR Freeze or its agents or employees in relation to the plaintiff's accident, and BR Freeze plainly did not exercise supervisory control over the injury-producing work of Canatel and its subcontractor, Canal Steel, plaintiff's employer. All of the evidence
You're the contractor responsible for the steel work, right?
I'm sorry, Your Honor?
You're the contractor responsible for the steel work.
No, that's Canatel.
That's Canatel. Oh, you're Freeze then.
I'm BR Freeze and BJ's. The construction contract,
Freeze leased the premises.
I'm sorry,
Freeze leased the premises, right?
BJ's leased the premises and BR Freeze had the construction contract with BJ's.
And then then Freeze subcontracted the steelwork to Canatel.
Yes, Your Honor.
Correct?
Yes.
I finally got that right?
Yes.
Okay, good.
And then there was a further subcontract on behalf of Canatel to Canal, which
To
is
further confuse it, almost the same name.
exactly, Your Honor. And it's our contention that the construction contract indemnification clause was not triggered and Thor Shore was not entitled to contractual indemnification from BR Freeze. And we showed the contrasting language between the 2007 AIA agreement and the 1997 AIA agreement. In addition, BR Freeze did not engage in any acts, breaches, or omissions or negligence or fault proximately causing plaintiff's accident and cannot be found liable to contractually indemnify Thor Shore. In addition, BR Freeze...
Counsel, what about the part of the contract that says they're responsible not only if the indemnification applied for the actions of Freeze, but for also any party for which it is responsible? Does that matter?
No, Your Honor. The word subcontractor was specifically removed from the 1997 version, which could have been selected by Thor, and it was removed, and Thor chose the later 2007 language, which does not include subcontractor, and the subcontractor here was negligent, Canal. Thus, it's our contention that they're not entitled to any indemnity from our clients. With respect to the lower court's correct granting of contractual indemnity in favor of BJ's and BR Freeze against Canatel, we argue that that was correct and that BR Freeze was not negligent in any way. And we've referred to the court's holdings in Capobianco and also in the Sonodato case. Thank you very much, Your Honors. I also rely on our papers. Thank you.
Thank you. You may proceed, Counselor.
Good afternoon, Your Honors. Sage Subik on behalf of Thor Parkway. Just by way of overview of the parties, Thor Parkway was the landowner. They leased the premise to BJ's. BJ's then subcontracted to BR Fries. They then subcontracted to Canatel Steel and then Canal Steel. We are only responding to the portions of opposing counsel's brief that deal with Thor Parkway's indemnification, and we ask that the court affirm the lower court's decision to grant contractual indemnity to Thor Parkway. The contractual indemnification language at issue here regarding Thor Parkway unequivocally establishes that BR Freeze agreed to indemnify and defend Thor. The opposing counsel relies heavily on the fact that BR Fries was not found negligent. However, BR Fries' negligence is not the only trigger to this clause. The language plainly reads that BR Fries has agreed to indemnify both BJ's and Thor for all claims arising out of all acts, breaches, failures to act, omissions, negligence, or fault. The use of the word or means that any of the foregoing can be triggers to indemnification of this clause. Here, there was a claim that BR Fries acted or failed to act responsibly towards the construction site to which they were solely responsible. The record is full of examples of how BR Fries claimed responsibility over the construction site. First, I can point you to a little bit earlier in the contract, section 3.31, it clearly states the contractor, BR Fries, is solely responsible for all portions of the work under the contract, which would therefore include also all the work the subcontractor conducts. Additionally, there's deposition testimonies from BR Fries' supervisor, Stephen Schofield, who testified that they were responsible for all safety inspections, all safety procedures, and were to provide the safety equipment. So just because they were not found negligent in this action does not mean the indemnification clause itself was not triggered by their failure to act accordingly and to employ all the safety procedures and practices and provide all the safety equipment. Additionally, opposing counsel relied on the fact that in the 1997 version, there was a word called subcontractor in there, and now in this 2007 version, which was actually signed, that actual word is not in the contract. However, the phrase, as Your Honor pointed out before, the phrase that they will indemnify for anyone for whom the contractor is responsible. Again, in earlier portions of that contract, there's two parts in which BR Fries claimed responsibility over the subcontractor, making them then responsible in that indemnification clause. I point you to section 3.31 of that contract. Again, the contractor is solely responsible for all portions of the work. And then 3.32, the contractor shall be responsible to the owner for acts and omissions of the contractor's employees, subcontractors, and their agent. It is clear that BR Fries intended to indemnify both BJ's and Thor under this contract, both for their actions and the actions of their subcontractor. I also would like just to point out and wrap up really quick that BR Fries has indemnified and defended BJ's under this language, and they have made no distinction between BJ's and Thor Parkway about why this language would apply to BJ's and get the indemnification, but not apply to Thor Parkways. With that, we just rest on our papers.
Was the argument regarding the language of the prior lease, was that raised before the motion court?
It was not, Your Honor. It was not raised on summary judgment. This is the first time we're hearing these two different versions and how that they make a difference. Again, under each version, we are still owed indemnity, whether it's clearly right out of subcontractor or, quote unquote, anyone with whom the contractor is responsible. There's many pieces of evidence on the record that show that BR Fries was responsible for the subcontractor, and there be held, and therefore it would be part of that phrase, anyone who the contractor is responsible, in that indemnification clause. Thank you, Your Honors.
Thank you. Okay, rebuttal?
I just want to make clear to the court that the action has been settled by Canatel with the plaintiff on behalf of my clients. And it's clear that they owe indemnity and additional insured status to my clients and are responsible for Canal's negligence. Therefore, even if the court were to disagree with our position as with respect to Thor, all of the alleged negligence would flow down to Canatel, and they would be responsible to Thor as well. Plaintiff's negligence would be imputed to Canal, which would go back to Canatel. With respect to the arguments by counsel, we have addressed all those arguments in our papers, and I thank the court.
Thank you. Thank you both.
Thank you.
Diop versus Getty Square. We have two respondents on that.
Good afternoon, Your Honors. Robert Menoff for the respondent plaintiff, Sunny Diop. So it's respondent's position that the lower court was correct in denying Hamidi's motion for summary judgment, that they didn't do enough on their motion to meet their burden. And there are certainly issues of fact as to whether or not they created this condition on the sidewalk The overall testimony of the non-party witness, is Mr. Gene Thomas, confirmed that the hole in the sidewalk was created by rodents that were emanating in the basement of this restaurant that had been going on for several years.
He's in the restaurant, or that it was just under the sidewalk?
Well, Mr. Thomas said that he noticed them in the basement for several years of the restaurant, which was in sole possession of this tenant, Hamidi, the appellant. And that was a recurring condition, and he saw holes on the sidewalk in previous years, and those conditions were caused by these rodents that were getting into the premises.
But doesn't the actual lease impose structural repairs on the part of the landlord and not the tenant? That the actual paragraph 4 makes it clear that they're only responsible for non-structural repairs like removing snow and sweeping on the sidewalk in front of the restaurant. And this was a hole which had asphalt put on it that became a trip hazard for your client, correct?
Correct, but also in the lease, there's a provision about the tenant being responsible for preventing vermin on the premises. So in our eyes, it's an issue for a jury to determine if there's one.
I'm just trying to understand this mechanically. So the accident here occurred because somebody tried to repair the hole, and the repair in the hole was this elevated kind of tar
Correct.
obstruction.
There was asphalt put on top of.
That wasn't created by the tenant, no question about that.
Well, neither party can say who performed that repair and as to either when it was performed.
Wouldn't that repair be the landlord's repair?
No one could say whether or not it was done by the landlord.
No, but under the lease, it was the responsibility of the landlord.
Well, under the lease, the landlord has the structural repairs, but the tenant also has the responsibility for preventing vermin from coming in.
Yeah, but even if the vermin created the hole, she didn't fall in the hole, she fell over the repair of the hole, right?
Well, it's a condition created then by the tenant. And
that apparently is your argument, okay.
Yeah.
All right, let me hear from the other respondent, thanks.
Okay.
All right.
Thank you.
Yeah.
Good afternoon, Your Honors. Ellie Herman for the defendant respondents. As you might imagine, I agree that there are tribal issues of fact and that the order should be affirmed.
Well, what's the tribal issue?
So I would say that the main tribal issue is, as the appellant said in their brief at page 17, they can't say who did this work. They simply don't know. They've decided that it has to have been the landlord. And Your Honor, I take your point about the lease shifting responsibility for structural defects to the landlord. The fact of the matter is the landlord says it doesn't know who did this, and the plaintiff's argument is...
What's the proof that the tenant did it, that the tenant did the repair?
Well,
I'm going to leave aside the issue that your co-respondent raises, which is that that the tenant may have created the hole.
Your Honor, it's not our motion, it's the appellant's motion. I don't have the proof that the appellant needs, which is why I believe the motion was properly denied. They can't establish who did this.
Well, didn't they submit this is Hamidi, it was the move-in, correct?
I'm sorry?
Hamidi was the move-in here, right?
Yes, Hamidi was the move-in here,
And in
yes.
support of their motion, didn't Mr. Hamidi submit his deposition testimony?
He did, Your Honor.
And didn't he testify that I didn't view this as my responsibility, making sidewalk repairs, I would make a complaint, and I didn't hire anyone to affect any repairs?
That's correct, Your Honor. He also said that he repeatedly, I believe it was, he said on a weekly basis, demanded that Mr. Thomas repair the sidewalk, which then brings us to the indemnification provision, and it's our position that the indemnification provision would then have been triggered because it was done at the request, which would be on behalf of Hamidi. And if I may finish, and then just to the argument about that being indemnification for the landlord's own negligence, that's resolved by the fact that there is an insurance procurement provision, and the parties have shifted the risk to insurance. Thank you, Your Honors.
Thank you. Thank you both. Faruqi versus Columbia University. You may proceed.
Good afternoon, Your Honors. I'm Marshall Bellavin, and I represent the appellant. May it please the court. In this case, the appellant was a PhD student at Columbia University who was characterized by his colleagues and eminent professors as a brilliant scholar, was dismissed from the PhD program by Columbia University, and it's clear in looking at Columbia's policy on good standing, which is found on page 112 of the record, that Columbia violated its own policy in dismissing the appellant in this case.
Counsel, the appellant was given several warnings or recommendations to take via email. He had to get his transcripts. They told him he was on academic probation. He needed to take a language course, the smoking in the dorm situation. Why is that not a basis that we should give deference to Columbia University for dismissing this individual from their program?
Well, in the case of the transcript, Your Honor, Columbia already had the appellant's transcript. The appellant had received a master's degree at Columbia. They had the transcript. He made good faith efforts to obtain another copy of his transcript from his undergraduate university in India. He was unable to obtain it. He explained that. He received a C in a course, and he was put on probation for receiving the C. He was fulfilling the terms of the probation. These are not enough to dismiss and terminate a PhD candidate when Columbia's policy calls for the following, Your Honors. Departments and programs advise their students who are not in good standing of corrective steps to take, the deadlines for doing so, and the consequences of failing to remedy the matter. A student who fails to take corrective steps within the specified time limit will be terminated from candidacy for his/her degree. That's on page 112 of the record. The main reason given in the letter of December 16, 2019, for terminating the appellant's candidacy was that he was dismissed from being a teaching assistant for a professor, and this was in November 2019. The timeline is important here. Within a month, or approximately a month, December 16, 2019, he was dismissed from the program. There was no advisement to him of what corrective steps he needed to take in terms of his work in the TA program. There were no deadlines set. There were no consequences, advisement of consequences for failing, corrective steps within a specific time limit, none of that. He was simply removed as a TA, teaching assistant, and As a teaching assistant, this was a prerequisite requirement for a PhD degree. He had to have it. Now, as pointed out by one of the number of professors and former colleagues of the appellant, they're in the record, their affidavits. The normal procedure would be to explain by the professor, to explain to the teaching assistant where he was failing, where he needed improvement, and if they couldn't reach an amicable accommodation, then he would be assigned to another professor. This was not done.
Okay, thank you.
Good afternoon, Your Honors. My name is Susan Friedfeld from Jackson Lewis on behalf of the respondents. May it please the court.
Counsel, with just picking up from where your colleague left off, in terms of corrective steps that weren't offered to Mr. Faruqi, why is that decision then to terminate him from the program, why should that be afforded deference?
Because the policy actually says that in circumstances where there's evident and extreme failure to achieve progress, that the probationary period is not required. And so here, once Mr. Faruqi was no longer permitted to be a TA because the faculty and the department and the GSAS administration had agreed that he was not capable of fulfilling the pedagogical requirements of serving as a teaching assistant, there was absolutely no way that he could progress in the program because he must teach for 2 semesters. And so once that decision has been made, there was no path forward. And so
Did they give him an opportunity to go with another teacher to be their assistant?
No, they didn't, and they considered that and evaluated it and determined that based on his conduct and performance, that they did not feel that they could, in good conscience, assign him to support another faculty member or to teach other undergraduate students. If I may, Your Honors, one point I did want to point out is that one of the arguments that the petitioner appellee makes is that there was some bias on the part of Mr. Slusersick, and that he wrote, there's a note in the reply brief, they indicate that Mr. Slusersick was the one who wrote the dismissal letter, which is not accurate. The actual dismissal letter is found on page 2122 of the record, and it shows that Dean Andrea Solomon is the person who signed that, and that Mr. Slusersick was only copied. And so to the extent that they're relying on some potential bias by Mr. Slusersick, there's no evidence in the record to support that. Excuse me. One point that the petitioner makes repeatedly is that he was on probation, and he was on academic probation, he was on disciplinary probation, and that he was fulfilling the terms of those probations. Now, we've indicated in our papers that the probations were not the cause of the decision to dismiss him. However, there's nothing inappropriate for the university to consider those facts when making their determination. It was the totality of the circumstances. It was permissible for them to consider those facts. It was not, there's no requirement that they be considered, that each thing be considered in a vacuum. With respect to the claim for the Article 78 proceeding, we would submit that there is no evidence that the university's decision was arbitrary, capricious, or an abuse of discretion. They properly exercised their discretion to determine what the requirements were for the program and whether or not the petitioner had met those academic requirements. Further, to the extent that the petitioner seeks to pursue his breach of contract claim, the case law is clear that you cannot pursue a breach of contract claim based on an academic judgment. And second, even if he were to argue that there could be a breach of contract claim based on this provision in the policy to which he referred with respect to opportunities for correction, as I indicated earlier, that a provision was not applicable because here there was a case of extreme and egregious failure. And with that, we'd ask that you affirm the lower court's decision. Thank you.
Thank you. Rebuttal?
the alternative path for dismissal of a PhD candidate, according to Columbia's own policy on good standing, was articulated by counsel. It's evident and extreme failure to achieve progress. Now, the only way that he could have achieved progress is if he was given a corrective path so that he would either be able to achieve progress or not as a teaching assistant. His students, who were the ultimate consumers of his teaching assistant work, 3 of them provided affidavits expressing shock that
I know that they did, but here's where we get into the issue of the deference that's afforded to the institution. They made a determination that he could not achieve the progress necessary for them to otherwise put him on probation. Shouldn't we defer to that?
if the decision was not arbitrary, if the decision adhered, I'm sorry, Your Honor.
Well, it would adhere to their policy. That was their policy. They say the standard was met. The fact that some students thought he was an excellent teacher doesn't undermine their determination, does it?
No, it does not, Your Honor, and that's exactly correct. However, the opportunity to be a teaching assistant, either for this same professor or for another professor, was never provided. They made a determination, Columbia did, that there was this evident and extreme failure. And it is on that note that there is an arbitrary and capricious dismissal, because he had no opportunity to contradict this determination. I mean, they're perfectly entitled to make a determination based on their own needs. This is exactly correct. However, they must adhere to their own policy. Thank you.
Thank you. Thank you both. Corey versus Italy, New York, next case.
Good afternoon, Your Honors. Mika Mooney here on behalf of the appellants Ally Barton Security Services, Ioanni Mena, Jordana Moran, and Michael De Los Santos. May it please the court, we submit that the lower court's decision denying summary judgment was incorrect. When looking at the record as a whole, respondents claim that the events transpired because of his sexual orientation simply doesn't hold up. On the evening that he appeared at Italy with his party, no services were denied to him. He missed his call for a table. He was told that his name would be put back at the end of the list. He became very hostile and aggressive. The video, surveillance video, represents that he is actually very hostile and aggressive towards Italy staff and the security staff. He's shown in being aggressive in people's faces, pointing their fingers, pointing his finger in their face. Members of his own party are shown to be pulling him back, stepping in
Let me
between him.
stop you for a minute, because the court below, she saw the video, and she said, you know, there's conflicting evidence about whether homophobic slurs were said to the plaintiff, at least with respect to the discrimination claim. You agree, there was no sound on that video, right?
Correct, there is no
So we
sound.
don't know if they were made or not. That's a contested issue of fact.
So for purposes of the motion for summary judgment, appellants accept that those comments were made. They were denied, but for the purposes of the motion, we accept that they were made, and we view them as stray remarks. They can't be
Let me ask
tied.
you about that stray remark theory, because this is a public accommodation case, right?
Yes.
And the relationships between people in most public accommodation cases are transient. It's not like the stray remarks that come up in the hostile work environments where you have a work situation and maybe there's a remark said one day, but 364 days of the year, life is good, right?
Correct.
So this concept of stray remarks in the context of public accommodations has got to mean something else, doesn't it?
Yes, Your Honor. However,
So here, there's at least allegations that you're accepting, at least for the purposes of this motion, that within a 10 to 15-minute period of time, maybe 10 remarks were made, right?
the record shows 3 remarks.
3 remarks?
Not 10 remarks. And I also want to point out there's a non-party witness that testified as that the security professionals were calm, they were not belligerent, that it was the
that's
plaintiff.
great. That'd work great if this weren't summary judgment. As you said, you have to accept yeah. I mean, that's great that you have that witness, and maybe at a trial that would prevail on the day, but we're looking at something that's so factually laden in the context of summary judgment, and that's what, at least for me, is providing me a little bit of questioning, discomfort for the idea that this kind of case fits into a summary judgment rubric.
I understand, but when you look at the record as a whole, you can't connect those comments to any of the events that transpired on that evening. The security officers didn't unilaterally decide to remove him from the premises. They were directed to by Italy. They didn't implement any force of their own volition. They
did throw him through a glass door. I mean, they said they had a reason, but he did go through a glass door, right?
It is in dispute that he was thrown through a door, but the plaintiff respondent admitted that he picked up an object and he threw it at them. This is happening in a matter of seconds, and to protect.
I know, but again, whether the proportionality of the force that was used, and there is an issue of fact about what that object was, I just don't understand how it's susceptible to summary judgment. Just putting it out there.
Yeah, if I may, I don't think, again, when looking at the record as a whole, that you could tie it to these alleged offensive comments that were made. And it opens the door for, in any kind of such claim, anyone could claim something happened and say it was because of a protected reason, or,
Well, not so. That's why we have trials. Okay, let's hear from your adversary.
Good afternoon, Your Honors. May it please the court. My name is Louis Bottolato from Stefano Filipazzo's office, and I represent Mr. Corey. My client, Mr. Corey, is a proud member of the homosexual community. And as Justice Billings correctly found, taking the facts in the light most favorable to him as the non-movement, there is ample evidence to deny summary judgment in this case. Contrary to my learned opponent's reading of the record, there are in fact at minimum five separate instances where homophobic slurs are used by the security guards that evening in that 10 to 15-minute period against my client. Additionally, the idea that my client initiated the violence is frankly ludicrous when you watch the video. By the admission of the other two guards, De Los Santos had to hold back the guard, Mr. Moran, from attacking Mr. Khoury long before the final instance where he's thrown through the glass doors. And they all admit it absolutely was completely improper for Mr. Moran to go at the plaintiff who had never touched him. The video shows the plaintiff never physically touched the security guards. He was in a heated exchange with them because they had called him absolutely abhorrent terms for homosexual people. And as a result, he got very upset. And frankly, I think any of us would have been if we were subjected to slurs against our religion or ethnicity or sexual orientation. The guards were very, very aggressive on the video with Mr. Khoury, not the other way around. As a matter of fact, Mr. Khoury turns and is walking from the restaurant on the video when, according to not just Mr. Khoury, but two non-party witnesses, the guard said, "See you later," homophobic slur, I'm not going to say it. And he turned around furious and picked up a refrigerator magnet that was for sale and tossed it in their general direction. The security guards and the attorneys for the security guards have consistently, in their briefing and before the court, below a court, said that he threw a bottle based on demonstrably false testimony, original testimony before the video was shown, where they all said, "Oh, yeah, he threw a bottle at us." And then when you show the video, they were like, "Well, yeah, he didn't throw a bottle, it was something, he threw something." So they're taking this position that there was this danger to the guards or to other people when they attacked him and threw him to the glass doors, when by their own testimony, which I...
But your object here, you're not trying the case here, you just want to put it in front of a jury.
Right, exactly. And so, viewing this evidence in light most favorable to my client, summary judgment was properly done. Justice Billings got it right. And as the court clearly understands my position, I will rest on my brief and allow rebuttal.
Thanks. Rebuttal.
Counsel mischaracterizes the testimony that when showing the video that it wasn't a bottle.
Does it even matter? Your clients say it was a bottle. The plaintiff says it was a magnet, issue effect. And then comes up the issue of the proportionality of what happened, which we do know. He did go through a glass door. There seems to be no argument about that.
They all went through a door, the door.
I
He
know,
was
but they're not
arrested,
all
they were
suing.
not.
They're not all suing for assault and battery. Right?
But the record doesn't tie that having to do anything with his sexual orientation. They didn't even know what his sexual orientation is.
Because you're mixing metaphors here. I thought he had a separate claim for assault and battery, and he has a separate claim for discrimination. Maybe he'll prevail on one and not the other, depending on what facts the jurors find, right?
Yes, he certainly shouldn't prevail at this stage on the discrimination claim.
He's not prevailing. He just wants to go to trial.
If the plaintiff were if the plaintiff were removed from the premises and there was no testimony regarding the use of homophobic slurs, I think you'd have a much different case. But there is deposition testimony that in the minutes leading up to his removal and while he was being removed, that homophobic slurs were used. At this, again, going back to Judge Gish's point, given the procedural posture we're in, doesn't that at least raise a triable issue of fact as to whether the reason given for his removal was pretextual?
The only testimony there is to that is his own testimony. We have a non-party witness who says she didn't hear any such comments being made, that the security officers were comporting themselves with a degree of professionalism. There's,
And those are credibility issues that can go before a jury. I think that's the point that summary judgment is about, right? Credibility goes before the jury. See who they believe.
I just do not believe that the record supports this case going to a jury on that point.
Okay.
When you look at it as a whole in the totality.
Thank you.
Thank you.
Thank you both. Colfin SMP versus Security National. You can proceed.
Good afternoon, Your Honors. It's good to be back in a court in person. Jeffrey Mitchell.
We agree.
Jeffrey Mitchell for the plaintiffs who are the appellants and lenders here. And I think in context to keep in mind here, the lenders have lost tens of millions of dollars on the loans that underlie the parties' dispute here. The transcript reflecting the IAS court's decision on the record to dismiss this case is pretty sparse, especially considering how much money was at stake for the lenders here. It consists of just 3 paragraphs. 1, dismissing the declaratory judgment claim because defendants supposedly admit their claim for management fees is not collectible. 2, that the court does not think servicing the manager here subordinated its right to file a lawsuit to claim its management fees in Louisiana. And 3, that the guarantee does not apply, or that the guarantee does not apply because it does not use the word affiliates. Essentially all conclusions with no legal reasoning for evaluation on appeal. The court's conclusion was basically this, and I'm quoting from page 7 of the record, quote, "I don't agree with plaintiff's theory that the use of the word claims precludes the defendant from filing the action in Louisiana," close quote. Putting aside whether interpreting an undefined word like that on a motion to dismiss is even permissible, then leave to file an amended complaint was denied, even though this was a first-time motion to dismiss, and the court itself said that the dismissal was without prejudice. Then, like a final nail in the coffin, the court entered a final judgment against plaintiff with costs and without the without prejudice language in the judgment, making it look like there was a judgment that plaintiffs had lost on the merits. All this on a pre-answer motion to dismiss. Now, you were just talking about a summary judgment motion. We're not even at summary judgment. This is a motion to dismiss.
But the parties' relationships were defined by contracts, were they not?
I'm sorry, Your Honor?
The parties' relationships were defined by their contracts that they made, correct?
The parties' relationships were defined by their contracts,
So
yes.
a lot of times we have 3211 motions based on contracts if all we're talking about is looking at the contract and interpreting it, correct? We can do that.
The court can interpret a contract on a
Right,
motion
so-
to dismiss,
so
no
why
question about
isn't-
that.
So why isn't this that kind of case?
Because the court doesn't explain its reasoning. First of all, the issue of claims, and if you look at the subordination agreement, the language itself, and we've quoted it in the brief, what was subordinated? And the subordination language, which is at page 848 to 49 of the record, uses the word claims, fees claimed by manager. That's subordinated. The petition in Louisiana, paragraph 9, this is at page 53 of the record, the petition says all of the defendants' owners are in breach of their respective management agreements by failing to pay all management fees, commissions, and other sums due Security National under the management agreements. That is subordinated now pending repayment of the lenders. So they agreed to subordinate their management fees, and they cannot make by the plain language of the subordination agreement, cannot make a claim for management fees. If you can't make a claim for management fees, how do you sue for management fees? And I don't think the court comprehended that and didn't explain its reasoning in how it comes to dismiss it with the use of the word claims. The court just says, I disagree with what you're saying about the word claims. I don't think that's, first of all, it's not clear and unambiguous in the contract. At best, it's an ambiguity for which parole evidence would be required and discovery.
Is there anything in the contract that expressly limits the rights of the subordinated creditor from taking any action against the borrower until more senior creditor's debt is repaid?
The whole context, yes, Your Honor, the whole point of this is that the lenders get repaid in full before the manager can sue for fees or recover fees.
Does it expressly say that, or is that you believe from looking at the contract as a whole?
The paragraph I just read to you, Your Honor, from the context of what this is provided for, think about the context of what we have here. We have a guarantee you're not going to interfere with our right to repayment. We have a subordination of management fees. All this is all under, these companies are all under the common control of this Mr. Arkley. So under his common control, he agrees, I'm not going to interfere, I'm not going to do anything to cause my companies to interfere, and I subordinate my rights to seek management fees and recovery of management fees until the lenders are repaid in full. That's all clear and unambiguous. And to the extent it's not clear and unambiguous, what did the parties mean by all these contracts is certainly something that the lenders could sue for. The lenders here are out a lot of money. It's not like this loan is ever going to be repaid in full. Tens of millions of dollars have been lost here. And this lawsuit in Louisiana is a lawsuit that is in derogation of the subordination agreement. Now, but more importantly, Your Honor, because I see the white light is on, I just want to point out one other thing. We're here in a motion to dismiss. Does the complaint state a cause of action? That's primary question one. It is undisputed that this is a case brought under the subordination agreements. It's undisputed. The lender is trying to assert rights under the subordination agreement, and the lenders are saying, we are entitled to certain relief vis-a-vis this Louisiana action. The subordination agreements themselves say, quote, any legal suit, action, or proceeding against the lender's borrower or manager arising out of or relating to this agreement shall be instituted in any federal court, federal or state court in New York, New York. That's what happened here. It's undisputed that this is a suit brought under the subordination agreements. It is preemptive and improper to dismiss the complaint on a pleading that states a claim under the subordination agreements. The court did not, I'm not sure the court completely understood that the lenders were not plaintiffs in Louisiana, might have thought the lenders were actually defendants rather in Louisiana, and that the lenders are not parties in Louisiana. The lenders have a bargain for right to seek relief in New York under these agreements by the plain language of the subordination agreements. It's not a question of whether they prevail at the end of the case at this point. It's simply a question of have they stated a cause of action, and the complaint clearly does that. Thank you.
Thank you. Thank you.
Good afternoon, Your Honor. Mohammed Faridi from Patterson Belknap on behalf of Security National Properties, the appellee here. At core, all of the lenders' claims hinge on the notion that the initiation of the Louisiana action by servicing triggered a breach of Sections 3C and Section 7 of the subordination agreement. I'll focus first on Section 3C. The law in this department is clear that in order for a senior lender, a senior creditor, to prohibit a junior creditor from taking action against the debtor, the subordination agreement, or the language in whatever agreement that the parties have executed, needs to clearly say that the subordinated creditor, the junior creditor, is prohibited from suing the debtor. And that's what you had in the Kornfeld case. In the Kornfeld case, that language was not present, and this court ruled that the junior creditor was not prohibited from taking action against the debtor.
So in the junior creditors agreement, there was a requirement that the junior creditors sue in Louisiana. Wasn't there?
Yes, there's a management agreement at issue in Louisiana. Now, that agreement does not contain a forum selection clause. The subordination agreements do, but the management agreement contains numerous terms that evince the parties' understanding and intent that suits related to the management agreements for the recoupment of the management fees, those suits can be brought in Louisiana. And in fact, that the argument that the lenders are making here today, and the argument that they made before Justice Maisley, is an argument that they made in the Louisiana State Court twice. And it was rejected twice. They made the same exact argument in the Louisiana Appellate Court when they sought interlocutory review of the trial court's decision, and that court rejected the argument as well, and it refused to hear the petition. So what they're asking this court to do, and what they asked Justice Maisley to do, was to disagree with the decision made by the Louisiana trial court as well as the appellate court. But setting that aside, even if you don't accept the decision of the Louisiana court, which we think is a valid decision, if you look at the plain terms of the written agreements between the parties, they unquestionably refute the notion that the filing of the Louisiana action triggers a breach of Section 3C. I want to point your honors to the very specific language in the subordination agreement, Section 3C. It says, this is record 848 to 849. The management agreement and any and all liens, rights, etc., owed or claimed by the manager or held by the manager, etc., are and shall be in all respects subordinate and inferior to the lender's right to the repayment of their loans. It doesn't say that the junior creditor is prohibited from suing the debtor. And I'll just use one example here, Your Honors. Think about a simple home mortgage loan. A homeowner takes out a mortgage loan, and that loan is secured by a first lien on the property. And the homeowner also contracts with the gardener or the plumber for services on the property. Their theory here is that the gardener or the plumber cannot sue the homeowner to liquidate the gardener's or the plumber's claim into a judgment until the senior mortgage lender is paid off 30 years from the date of the note. And what that would do, this court dealt with that very issue in the Nordberg case, and the court said, you don't have to wait. If you wait, you're going to run the risk of a statute of limitations defense on part of the debtor. And that's exactly what would have happened here. If the management company did not take action in Louisiana and did not seek to liquidate its claim into a judgment, the property owners would have made the argument that, look, your time has run out, the statute of limitations has expired. And that's the very reason why this court has ruled in Kornfeld that you need the type of language that you actually had in a different case, in the J-Bar case. Remember, that's another case from this court. And the agreement at issue in that case expressly said that the junior creditor is prohibited from suing the debtor. And the J-Bar court contrasted that language from the type of language at issue in Kornfeld, which is exactly the type of language that we have in the subordination agreements at issue here. And the J-Bar court said that's the type of language that you need in order to prohibit the junior creditor from taking action. They don't talk about Kornfeld in their opening brief. What they say is, well, Kornfeld is not applicable because in that particular case, what you had was a subordination, a provision in a note agreement, not a standalone subordination agreement. But that's a distinction without any meaning. That doesn't change the fact that you've got a provision which is clear and unequivocal.
Thank you. Rebuttal?
I just want to start with the first thing. This is not a plumber or a gardener. This is an affiliate of the borrower managed by the same people at the time these management fees were supposedly accrued. And the parties you can see the size of the record here, that we didn't attach all these. The defendants attached all these as if it's a summary judgment motion. These are all the loan documents. The point of all these documents is the lender gets paid first before the servicer gets paid, before you get paid on profits, and there's a whole laundry list of things in the loan agreement that creates a waterfall of who gets paid when. So the point is, this is not a third-party plumber. This is a party that signed many collective documents, and the court jumped the gun by interpreting, it's not just one provision, but many documents together that need to be read together in order for us to have the day in court. It's also not true. The issue is not simply whether they can bring the claim in Louisiana, but what could they do with a judgment in Louisiana if they get one? They admitted in court, not the plaintiffs, by the way, not the defendants, by the way, by affidavit, but the lawyer admitted in court, we can't do anything with the judgment. We're just doing it to get a number reflected in a document. Well, that's not what the claim is in Louisiana. The claimant is for money damages. It's to get a judgment in Louisiana that then is entitled to full faith and credit in every one of the 50 states in the United States. And we're entitled to a ruling in this court on several things. One, to make sure that our priority is maintained if a judgment is ever entered, because we do have risk, and in declaratory judgment actions, satisfying or solving future problems is what declaratory judgments do. Second, the issue of collection of that judgment, if they have an unfettered judgment in Louisiana, we're entitled to a judgment from a New York court that says, one, you have priority and your priority is maintained. That's number one. And number two, because it would be part of this case, you've never been repaid in full. So this is not a plumber or a gardener. This is an affiliate of the borrower who's trying to extract money from a transaction in which the lenders have already lost tens of millions of dollars. The case in Louisiana is an affront, and the lenders sued where they're entitled to sue to get relief in New York so they get a judgment that protects them in the event a Louisiana judgment is ever entered, and that it cannot be enforced in another state. Thank you, Your Honors.
Thank you. Thank you both. People versus Ramos. You can proceed, Counselor.
Good afternoon, and may it please the court. My name is Amelia King-Musa, and I represent Mr. Carlos Ramos. Mr. Ramos' Level 2 SOAR designation overstates his risk of committing another sexual offense. The risk assessment instrument did not properly take into account Mr. Ramos' serious medical conditions or his age, particularly in the context of his age when he committed the instant offense.
Counsel, isn't one of the factors when we look at what his age is now, the fact that he absconded for several years?
Yes, Your Honor. Unfortunately, very unfortunately, he did abscond. However, the SORA risk level determination itself is very specifically simply for the purpose of determining his risk of committing another sexual offense, not just committing a criminal offense in general. And while these circumstances are certainly regrettable that he did abscond, Mr. Ramos had some time living on the outside world. And between his absconding in 1985 and his return to court decades later, he did not commit another sexual offense.
Isn't that considered under factors 5 and 9?
Yes, Your Honor, it is. I was simply addressing that we have some information about his whereabouts in the, or his behavior in the outside world. The RAI took into account his lack of sexual offense before this offense was committed. The RAI does not take into account criminal history after the instant offense was committed. Now, this was, as I referenced, an isolated incident that occurred over 35 years ago. Mr. Ramos is now in his 70s. He is legally blind and requires the assistance of a sight guide to navigate his facility. He has degenerative discs in his back and his hips. He had a hip replacement surgery, which unfortunately had complications, and he still cannot walk without a brace in addition to the sight guide. On the topic of the brace, very briefly, I just want to address something that my adversary wrote in their brief, stating that the extent of Mr. Ramos's mobility conditions are not substantiated in the record. They are. Notes of a brace are included in the doc's medical records, particularly in Exhibits D and E. Now, if there are no further questions, I would like to reserve the rest of my time on rebuttal.
Well, under our decision in Medina, don't we look in a case where the defendant is claiming a medical condition that was not properly considered under the factors, don't we look to see whether there's medical support or expert support for that claimed medical condition?
Yes, and there are, in the medical records, in the record, there are notes that he has a brace by doctors. You know, it's documented that he has degenerative spurs in his hips and his lower back, and that he needs a sight guide and, assistance walking around his facility.
But do you need, and this is a question, do you need something more? In other words, maybe a medical opinion or something that would connect up these health conditions and whatever their severity is to his propensity or his risk of recommitting sex offenses. So in other words, just the fact that somebody's blind doesn't mean that they're not capable of committing sexual offenses, right?
Yeah, that is correct, Your Honor. And under the framework set out by the Court of Appeals in Galati, the SORA risk determinant, the appellant only needs to establish facts in support by preponderance of the evidence. So that's what we're saying here is given all of these medical conditions and his age, it would be more difficult for him to commit another offense, and his risk is substantially lowered. Thank you.
Okay, thank you. Go ahead, Counselor.
Robert Myers for the Office of Darcel Clark. Good afternoon, and may it please the court. This court should affirm the SORA court properly adjudicated defendant as a level 2 sex offender and providently exercised its discretion when it denied his application for a downward departure. I do want to emphasize, defendant does not dispute any of the SORA court's point assessments under the RAI, under the risk assessment instrument. His sole contention is that the court erred when it denied his application for a downward departure. But defendant fails to identify a mitigating circumstance that's not already considered by the guidelines.
What about
even
his
further-
medical issues? How were those considered?
And
How were those accounted for?
Yes, Your Honor. I can proceed through the list. I'll note initially that his criminal record, as has already been noted, was considered properly under Factor 9.
I'm not talking about that. I think counsel's arguing that he's in such poor physical condition that even if he wished to reoffend, he couldn't physically achieve it.
And yes, Your Honor, in regards to his physical condition, in regards to his age and illness, age is not a mitigating factor here. Defendant has committed numerous
Well,
felonies.
age on its own, we've ruled, is not a mitigating factor many times.
And
But
yes,
what
Your Honor.
about that combined with his lack of sight, his hip replacement, his need for an assistant, a guide, and the other various medical issues that counsel referred to?
And yes, I do want to note that despite his advancing age, defendant has continued to commit crimes into his 60s. In his 50s, he committed and was convicted of 8 felony offenses.
Well,
and
now
7
we have him in his 70s, but if I read it correctly, he didn't commit any additional sexual offenses from the first one to now. Am I correct about that?
And you are correct, Your Honor. He has committed Tier 2 and Tier 3 DOCS violations while incarcerated, but he has not been convicted of any additional sex crimes since that time. However, I would note
Did either of the DOC violations involve any sexual assaults or anything of that nature?
and that's not within the record, and I don't know that, Your Honor, although the case summary does note those violations. But I would emphasize that defendant has not identified any period where he's been able to live a law-abiding life. He absconded after he committed this sex crime. He actually initially absconded after his arrest.
The point of the SOAR registration is to prevent him from committing further sex crimes, correct?
And yes, Your Honor. Yes, Your Honor, that is correct. But again, given the fact that he has not demonstrated, unlike Stevens or Green, the cases he cites, that he's physically incapable of experiencing sexual gratification or taking physical action to pursue those sexual desires. And so I do ask that this court affirm the judgment of the SORA court denying defendant's application for a downward departure.
Thank you. Rebuttal?
Very briefly, Your Honors. It is true that none of these ailments directly prevent Mr. Ramos from experiencing sexual gratification, but the standard is whether they make him less likely to reoffend, and that they do. His mobility is severely impaired, and his strength is dramatically curtailed. And then the last thing that I want to note is that his registration requirements, even if this court decides to downwardly depart, will continue for the rest of his life due to his designation as a sexually violent offender. So he will be continuing to register for the rest of his life. And
What about the community notification requirement if there was a downward departure from 2 to 1?
that, I believe, is where the largest change is. Level 1, he does not appear on the website, the sexual website.
Okay,
Thank you, Your Honors.
Thank you both. Right, the next case is Lopez versus Limpaex Cleaning.
Thank you and good afternoon, Your Honors. If it please the court, Marcia Rakes for the plaintiff appellant, Dory Lopez.
You may proceed.
That's me. And I would just like to say that there's significant evidence in this record, namely provisions of the contract, that show that one of the Espinal exceptions has been satisfied in the case at bar. Limpaex completely displaced the owner of the premises, the United States Government, Government Services Administration. Section C4 says that the government line of supervision of the contractor's activities shall not be exercised. There's Section 2B that says that it's a similar provision. Now, the Honorable United States District Judge Wood found that Limpaex retains autonomy for their day-to-day operations. That's record 1139. At record 1340, the government relegated full responsibility to the contractor. And all of this supports the finding that an Espinal exception has been satisfied.
Counsel, how many hours a day was Limpaex on the premises?
I believe from 7 a.m. to 5 p.m., an 8-hour shift.
The federal action that you mentioned, that it didn't really decide the issue of Limpaex's exclusive control or what they did on, it was really about subject matter jurisdiction in the context of whether or not they were an independent contractor or an employee of the federal government, right?
Well, I think it was determined that Limpaex was an independent contractor, not a government employee.
So the only issue that was decided there was the subject matter jurisdiction issue.
But the restriction on the government exercise of supervision pertains to supervision of contractors. And there's 2 decisions by the United States District Judge that were never appealed by the by Limpaex. And the issue was fully litigated, and Limpaex is collaterally stopped from relitigating that issue before this honorable court at this time.
The supervision for that's required for federal jurisdiction, you believe it's the same issue as for the in Espinal for the contractor occupying the field? Do you think that's the same, identical?
Well, I think they're finding contractual provisions and prior determinations in the federal court that support the conclusion that the contractor completely displaced the owner, United States government, and GSA with relation to the maintenance of the premises in a reasonably safe condition.
Okay. Thank you.
Thank you. And let me see.
Well, your time is up, so you'll have some time on rebuttal.
Sorry.
Right?
Good afternoon. William Crow for the appellant action carding. May it please the court. My colleague touched on a lot of the same arguments that are present in our appeal. I just wanted to, one thing that I know that the court had inquired about, because one of the issues that was brought up is that we do believe that collateral estoppel is applicable in this matter due to the decision of Justice Woods. And I know that the court had inquired with regard to that being a subject matter. You know, they were getting to the basis of subject matter jurisdiction. But we believe that when they were making that decision, or that analysis rather, they were looking at all of the factors that were present in this case, meaning that in this case, the Limpaex had, when they were deciding whether or not they were an independent contractor, they looked at all these factors and they found, and Judge Woods says it it's undisputed, he says, they had completely displaced the owner and were fully responsible for all cleaning, maintenance, all of the janitorial duties at the building at the time that this accident occurred. They were there at they started at 7:30 in the morning. It's undisputed this accident happened at 7:50. And he looked at that when making that decision that even though it was a subject matter issue, the analysis was the same, and he came out and he was very clear in saying that that Limpiex had taken on full responsibility and had displaced the owner with regard to all maintenance and janitorial and
But the
cleaning
court
duty.
didn't specifically refer to Espinal.
I'm sorry?
The court didn't say, gee, I'm applying New York law in Espinal to make this determination, did it?
It did not with regard to Espinal in making that decision, but in terms of coming to the conclusion with regard to deciding whether or not this was an independent contractor or whether or not they looked at the factors that were present and basically said that this company, Limpiex, had displaced the owner in terms of taking on full control of the maintenance and cleaning of the area in question on the date of the accident.
But under New York state law, aren't there two requirements for collateral estoppel? The first is the identical issue must have been resolved in the prior proceeding?
Correct, and it's our position that that issue was resolved by the court, by Justice Woods. He in his decision, he's very clear that he says that they were responsible for doing this. They had under this exhaustive contract, they were responsible for maintaining this area and were fully, that the building did not, that they had displaced the building in terms of their cleaning, maintenance, and of the area in question on the day of the incident. Thank you.
May it please the court, Michael Kazores from the Law Office of James J. Toomey on behalf of Limpiex. The decision should be affirmed for numerous reasons, some of which were not even discussed here today. Judge Wood of the U.S. District Court did not decide this exact issue. He didn't even decide an issue that was close to this. The only issue before the federal court was whether or not Limpiex was an independent contractor. Limpiex was an independent contractor, and therefore any negligence of Limpiex, any negligence, could not be imputed to the federal government under the Federal Tort Claims Act. Therefore, the U.S. District Court had no jurisdiction, and that's why the federal case was dismissed. That was not the same issue that was decided here.
Right, and in fact, we don't have a rule of law under Espinal that says just because you're an independent contractor, you have liability under Espinal. It may be a factor that's considered.
I agree, Your Honor. Espinal, and more specifically the third factor that's at issue here, was never touched upon whatsoever in the district court. And as Your Honor had pointed out, there are two factors that need to be considered. Not only identity of issue, but that the parties, that there has to be a full and fair opportunity to have contested the issue in the prior case. The burden is on the plaintiff here and Action Carding to show that there was a full and fair opportunity to litigate that prior issue, even assuming if it was an identical issue. There was not a full and fair opportunity. The district court made the determination on a motion to dismiss before any discovery had taken place. Since that decision was made, there were 10 depositions or more taken in this case. There was extensive discovery, years of litigation, and only then did it come out during discovery that the federal government maintained a property management office at the premises, that it maintained 24-hour-a-day security, that the security guards even kept a bag of powder in their booth to remedy any oil spills that occurred in the loading dock that they had responsibility over. So a lot of discovery has come out since then, and based on that fact alone, I would submit that we don't did not have a full and fair opportunity to reach that issue. Another factor that's important, which hasn't been discussed at all here, is that what we've been talking about up to this moment was whether or not LimpyX had a duty to the plaintiff here. No one's ever really addressed whether that duty was breached. We have made a prima facie case, both before the Supreme Court and I believe we've demonstrated in our brief, that LimpyX did not have actual or constructive notice of this condition. The plaintiff's theory of liability is that our co-defendant, Action Carding, spilled this oil from a recycling truck at 1 a.m. in the morning. And then she had her accident at 7:50 in the morning. It's absolutely untrue that my client, LimpyX, was doing work or on duty at 7 a.m. or 7:30 a.m. What the contract provided was that they had to provide 8 hours worth of service between the 10-hour period of 7:30 a.m. and 5:30 p.m. All the testimony in the case, and it's unrebutted, is that LimpyX provided that 8 hours of service between 8 a.m. and 5 p.m. So LimpyX was not even on the job yet on the day that the accident happened. So they had no notice, they weren't even there, and their first notice was when they got a call from the security guard employed by the federal government after the accident that, hey, there's this spill, you need to come and clean it up. And for that reason, I believe that the decision should be affirmed.
Okay, thank you. Rebuttal from the plaintiff?
I would like to cover two other contractual provisions that I think favor the determination that LimpyX displaced the owner of the premises. Section C9 required LimpyX to establish a complete quality control program to ensure that the requirements of the contracts are provided as specified. That's not relevant, or the hours of the day that's not only in effect certain hours of the day. Section E provides that LimpyX is responsible for the day-to-day inspection and monitoring of all work performed to ensure compliance with contractual requirements. That's Record 1339. Again, I think that these two contractual provisions are not limited to certain hours of the day. Additionally, LimpyX's argument that it had no notice may be, well, it's substantially challenged because a LimpyX employee, Felipe Guevara, told Fabio Guiguer to notify her of the accident, and he reported that GSA security guard informed him that a truck from Action had spilled oil, which Felipe, the LimpyX employee, works on remediating by putting powder down on the spill. Why was the LimpyX employee remediating the oil condition if they had no connection to it, no responsibility, or were on duty during those hours of the day? Thank you.
Okay, thank you. All right. Co-appellant?
If I may, just to touch on something that was brought up by the co-defendant. With regard to the federal action, LimpyX was a party to that action. At the time it was litigated, there was also an exhaustive review and analysis of the contract by Justice Woods at the time. So I just wanted to make that clear to the court. And then additionally, with regard to the Espinal, analysis.
Before you go there, the dismissal, the federal court's dismissal of the granting of the United States government's motion, was that with or without prejudice?
I believe that was with prejudice, I believe. With regard to Espinal, it's our position that there's clearly an issue of fact that there was a duty owed to the plaintiff, and that that LimpyX had breached that duty based upon the requirements of maintenance and cleaning in the contract, We do not feel that the plaintiff made, that the co-defendant made their prima facie case. In terms of constructive notice, they did not provide any sort of maintenance records as to when the area was last inspected or cleaned. And we just feel there's a clear issue of fact, and that the lower court erred in granting the summary judgment motion. Thank you.
Thank you. Thank you all. The next case is Medina versus Millwood Market.
Michael Flax, pro se, for appellant. Your Honors, I would like to succinctly highlight 2 points. First, the applicable decisions have ruled that an outgoing attorney that is discharged before depositions is only entitled to 5% or less, which is why Judge Tewitt's award of 20% was an abuse of discretion, even if Mr. Newman had provided adequate legal services, which he didn't do. Secondly, pursuant to Hines versus Killigan, the incoming attorneys are entitled to the entire legal fee. Because Flax-Zellen redid Newman's deficient complaints and bill of particulars, and thereafter conducted all the depositions, figured out and proved causation, prepared and argued the motion for summary judgment, formulated the damages proof with 5 experts, and negotiated the $2.5 million resolution despite the severe hurdles on damages. And because Mr. Newman misunderstood the evidence, which led to a more perilous litigation design, not deserving of a legal fee. The key, a key element driving a zero assessment here, Your Honors, is Mr. Newman's endangering lack of comprehension of the evidence. Mr. Newman mistakenly postulated that the partial collapse of the roof was foreseeable because the underlying decking was supposedly always known to be deteriorated upon the removal of the asbestos roofing, which led him to the egregious notion that the saw cutting was superfluous in this matter. Next, he hazardously touted the Hemmings report, even though it contradicted the plaintiff's account of the accident. And he erroneously, dangerously asserted that the Hemmings report conclusively proved deterioration caused the accident, and that the alleged deterioration was foreseeable, even though the Hemmings report did not state or imply that. And most damaging, once discovery revealed that workers had walked over the center of the roof where the accident took place before that area was saw cut without incident, Mr. Newman still recklessly advocated that deterioration, deterioration as an alternative cause of the accident, which contradicted and undermined the credible proof that the saw cutting and not deterioration was the cause of the accident.
Let me just ask a question, because the hearing court found that the dismissal was without cause. Is the issue here really the amount of the fees that were awarded?
Judge, we argued cause, and I could briefly discuss that. That was one of the decisions made, but our main position is that it was an abuse of discretion to award 20% for merely doing pleadings, bill of particulars, and the initial discovery responses, especially when...
and an investigator, right? There was an investigator that went out?
Yes, an investigator went out and got the Hemmings report, which Newman touted as his most significant contribution in this matter. But it turned out to be proven to be totally useless because, the Hemmings report asserted well, Mr. Newman asserted that it proved conclusively that deterioration caused the accident, the alleged deterioration was foreseeable. But the Hemmings report didn't say that or even imply that. In fact, the Hemmings report was proven below to be totally lack of credibility. It was an exculpatory statement made by Mr. Hemmings, and the underlying assertions that he made were totally inconsistent with the credible proof, specifically Mr. Vanderwood's testimony as to how the accident happened, which he said the accident happened, and Mr. Medina confirmed. Mr. Medina was walking on a planking which opened up. The Hemmings report says that there was an underlying exposed defective beam which caused the accident. Totally inconsistent. It doesn't even mention the saw cutting. It obviously was a false report, which Mr. Newman touted as being important.
I'm going to ask you to finish up, and you'll have time on rebuttal.
The bottom line is that the case law says 5% or less, and in this case, 0 was warranted because we had to redo everything Mr. Newman did, and he lacked understanding of the evidence, which led to a terrible litigation design.
Good afternoon, Your Honors. May it please the Court, my name is Paul Biebel. I represent Mr. Newman. And frankly, I think Mr. Flax misconstrues the reason we are here. We're not litigating the underlying case. The question is, what is an appropriate fee distribution, an apportionment of the fee? My understanding is that this court and other courts in this state have succinctly found that the individual circumstances and equities of each case should be determined by the court to determine what is an appropriate apportionment of fee. In this case, we have Judge Tewitt, who without doubt, upon this record, went through close to a week of hearing testimony, went through thousands of pages of documents before she rendered her decision. And her decision spells out the reasons for her determination of the apportionment of the fee as it relates to the quality of the work, the amount of time put in, the skill involved, all the factors that this court and every other court deciding apportionment of fees has enunciated or required and appropriate. So thus we were faced with the question is whether or not did Judge Tewitt abuse her discretion and base her decision on no rational basis from the evidence presented to her from the hearing, the testimony, etc. Let's talk about, first of all, the quality of the work. Mr. Flax asserts that the quality of Mr. Newman's work was, I guess, worthless since he's saying 0%. The court found exactly opposite to that. In fact, the court was presented with evidence that the quality of the work performed by Flax so endangered this case as to be a valid basis to reverse the concept of what his concept of what the fee should be. In this regard, he created a list for Mr. Medina to be used to refer to his medical records during the course of a deposition. We all know, it's no mystery, that in a 240 labor law case, the most important factor that you have as a plaintiff is the credibility of your client. He allowed Mr. Medina to testify falsely that he created this list. It was Mr. Flax who created it. That his son created this list, that he told his son to create the list. This went on for, according to the affirmation and opposition of a gentleman on behalf of one of the defendants, went on for about an hour. He then wrote a letter saying that his client, and it was his client who said to him, why didn't you tell them that you made this list? If there had been quality work behind what Mr. Flax did, as soon as the question was asked, who prepared this list, a attorney with any experience and any quality, frankly, would have said, by counsel, I prepared the list. When he went back for his subsequent deposition, he was subjected to another hour or so of torture regarding his false, perjurous statements regarding the list. He then, to compound this, Mr. Medina testified multiple times about the cause of the accident, and he testified multiple times that it was deterioration from his observation that caused the fall. He then had his client execute 2 separate affidavits saying, no, it wasn't what I testified to under oath. It was now saw cutting, something he had not mentioned in any accident report, he'd not mentioned anywhere else until this summary judgment motion. That was not granted, by the way. The time involved, we went through his timesheets, and it turned out that, frankly, he called them estimations and approximations. I think that would be generous to say. It was evident that they had been doctored. It had been evident that there were dates put in there from, for example, in 2014, he went back and wrote a date in 2018 in the same section. These were clearly doctored. 3 different timesheets were submitted, each supposedly exactly the same, but all with increasing numbers as they were presented to the court. In terms of...
I'm going to ask you to finish up your argument.
Oh, I'm sorry. I apologize. I'm finished unless there's any questions. Thank you.
Rebuttal?
Judges, I'm not going to consume my time rebutting the shameless accusations which were just made by Mr. Bilbud. They are all dealt with and debunked completely in my reply affidavit. I will state that the decision in Hines versus Killigan, where the court was faced with similar circumstances and reversed a 95%, 5% allocation and made the following pronouncement, which best summarizes appellant's position here. The plaintiff's former counsel provided no time records. Its contributions were minimal, and its efforts were ultimately of no value, as all of its work had to be duplicated by the plaintiff's current counsel. Accordingly, the appellate court determined that the incoming attorney was entitled to the entire legal fee, which is what the evidence warrants here.
Thank you. Thank you both. Bacon versus City of New York.
Good afternoon, Your Honors, and may it please the Court. I am Ralph Franco with the offices of Jonathan Rosenberg for the plaintiff and appellant Janelle Bacane. Your Honors, if I may rest on my brief with respect to points 1 and 2. In brief, our position is that no permissible line of reasoning could have led to this jury verdict in light of Officer Eastman's testimony concerning the manner in which he was proceeding under what he conceded was not an emergency circumstance. Your Honors, what I'd like to do is request that the Court invoke its interests of justice jurisdiction on a point concededly not raised by us in the papers. And what I'm getting at, Your Honor, is the law, Your Honors, is the law of the case doctrine. And I would point out at pages 488 and 489 of the record.
You didn't raise it in your appellate brief either.
We did not raise it, Your Honor. That's why
How
I'm
could
asking.
you ask for it at oral argument? There's not even the other side here.
I understand, Your Honor. I felt compelled to ask the Court to consider this on the interest of justice. If I may just briefly be heard, Your Honors?
You still have 2 minutes.
Thank you, Your Honor. Your Honors, the trial judge determined that based on the officer's testimony, that ordinary negligence applied and the reckless standard did not. I have gone through this record multiple times, Your Honor. Between pages 823 and 830 with that colloquy on the record, I still cannot figure out how the Court ended up charging, in essence, both recklessness and negligence. It seems that the jury was confused and that the nature of the
Make an objection to the jury instructions during the trial?
There was objection by counsel, Your Honor. Counsel did cite the, and I believe it is in that colloquy, Your Honor, between pages 823 and 830, and I believe again on page 894, where the underlying plaintiff's counsel pointed out that the recklessness issue had been dealt with in the motion record. So it seems very odd and inexplicable how the judge got to that interrogatory, in particular given the officer's testimony, which clearly established it was not being treated as an emergency. No lights or sirens, 25 miles an hour for the entire time that the call had come through up until the point of the accident. So we would ask the court, Your Honor, to look at that and consider that invoking the court's interest of justice jurisdiction.
Thank you.
Thank you very much, Your Honors.
Easy.